Okay. Want to repeat that for the record?
Good afternoon, Your Honor. Sarah Brenner, Assistant Attorney General to the people. I'm going to come stand.
Your Honor, Jeffrey Kaplan, P74943, on behalf of the defendant, who's not present. He's not actually a defendant technically because the case has been dismissed.
Yes, Your Honor, this is my motion to ask you to reconsider. On February 11th, we had a calendaring error on our end and my attorney didn't appear. And so you had dismissed the case. And I'm asking you to reconsider that decision today and reinstate the case. We apologize greatly for having messed up our calendar that day. And we're hoping that you can reinstate because I can't reissue the case because of statute of limitations issues. This is an older case. The defendant does live out of state, but we had finally got him on the right track and he's making payment efforts to reimburse.
Right, which is one of the reasons you weren't here, no one was here, we waited. And he went, this was a ridiculous case from the beginning. I don't know, maybe that's how the 18,000 was accrued, but he had a 6-cent wage assignment. That was remarkably, I don't know what the word is, but it was stupid to say the least, because a stamp is, I mean, if one stamp would pay his child support for the year.
Well, it's actually higher too, Judge. So he's got 4 different cases in 4 different counties here. So his withholding is much higher. It's just that's the only amount that trickled to Ingham County before he had directed the payments. And so he began directing.
Right.
So he is making efforts on his cases now. So I'm just asking.
Right, but that's why I'm wondering, do we need to do anything? He's doing, I think, $200 a month and he hasn't missed for a while. So he's making a dent and I guess we can keep him and watch him for 5 years, but why?
I just want to make sure that we have some consistency from him. And I did speak with his hopefully future counsel about that I would be flexible with him because he has been proving himself. And this was just a misalignment of calendars that had this occur. So, Your Honor, I'm just asking for your grace in this so that I can continue to help the victims and make sure that he is on the right path now going forward.
I always like to give grace, and I mean, clearly it was human error, but I'm just wondering the need for it because we have a new address, he's got a wage assignment in place. I mean, I don't know. Counsel, have you talked to him?
Your Honor, I haven't talked to him because, you know, the case is dismissed. I'm not going to encourage him to, you know, agree to the reinstatement. I'd be committing legal malpractice if that were the case. You know, if the case is reinstated, of course, I'll speak to him. Just so the court's aware, this is the second time this case has been dismissed. It was dismissed in district court because no notice was sent to the Attorney General's office about the probable cause conference. So, you know, and then it was reinstated.
Either?
I'm sorry?
We weren't given notice of that, Judge. So then we made a motion and brought that to the court's attention. So they reinstated because we hadn't been invited to that party.
Correct, that's correct. So now it's the second time it's been dismissed. And, you know, I am certainly sympathetic to scheduling errors. With my history, I can't be too critical of that. But nevertheless, this is about my client. And this is now the second dismissal that's not any fault of his. And being in Maine, this is a hardship for him. As Miss Berman has mentioned, it's Brenner, sorry. As Ms. Brenner mentioned, my client did make his most recent payment in February. I think it wasn't $400 a month. I think it was $200 a paycheck. So I mean, it would work out to $400 a month or $600, depending on how many paychecks were in that month.
So we never even had a plea in this or
No.
pretrial.
We did not.
We had 2 previous pretrials, Your Honor, where counsel had asked for adjournments to give his client time to start making additional payments, which the people agreed to, and so did the court. And so he had 2 adjournments, and that was our 3rd pretrial date that we had our error on.
And now he's doing what you want him to do. So I reinstate this and then what?
Then we monitor him going forward to make sure he continues doing what he needs to do. And if he does that, then we'll be looking at a reduced charge, maybe some probation, or maybe even, well, depends on how he does going forward. We're looking at between all of his cases, it's over $115,000 he owes to his kids here in Michigan.
So there are other files open.
Not felony files. They're all older children. They're in different counties around the state.
All right, I'm gonna reinstate the case. This is the last time. Don't care what happens. This is unfair to him. I understand errors. They happen all the time, but 2 in 1 file really is bad. It's a bad look for everybody.
I understand, Your Honor. Thank you.
So I'm gonna reinstate it and do trial. Or do you want a pre-trial? You want to delay it, or you want it a couple of weeks, or what?
I think the best thing would be to kick it out. I expect that we're probably gonna have to resubmit another wage assignment.
I
The
don't,
last one would have been terminated.
well, I don't know if it would have been terminated or
I
not.
told him clearly that he had better not, that if it needed to be redone because of the way it was done through the court, or however, he needed to do a new one.
Okay.
Right. Well,
I
I
made it
think,
very clear to
yeah,
him.
no, exactly. I
So
think-
yeah, I would, whatever amount of time you can give us, Your Honor, is more beneficial to the defendant and just gives him more time to continue chipping away.
All right, a pretrial shall be held September 16th at 10 a.m. Defendant is allowed to appear on Zoom as he's out of state.
Thank you, Your Honor.
Thank you, Your Honor.
Meet with everybody's schedule. It's far enough out there. We're gonna make sure you all get copies.
Yes, Your Honor.
Absolutely.
Thank you.
Thanks.
Thank you. It's all for the record.
Understand.
Thank you, Damon Bellis.
Which one?
College. College.
No, I didn't know her.
Like, I don't think I said no.
Mr. Kaplan, you want copies of this order? I think the AG left. I don't know if they will have.
I was wondering. That's why I wanted to.
Oh, there you are.
We were talking and
Gotcha.
we lost.
It is print page 2. Give me a second.
Judge Tyford?
This is docket 25-2528 FH, people of the state of Michigan versus Damon Edward Gullidge. Counsel, your appearance for the record.
Good afternoon, Your Honor. APA Bart Buxton on behalf of the people of the state of Michigan.
And thank you, Your Honor. Jonathan Foreman, Office of the Public Defender, here with Mr. Golich, just to my right. I'll just note that an appearance in my name, an amended appearance, should be coming forward to the court. I doubt he's gotten here yet, though.
All right, and who are you replacing?
Dwayne Silverford.
Okay, thank you. There's a whole lot of that going on, so I appreciate you placing that on the record. I was trying to do that earlier this morning and half my dockets, different attorneys now.
Understood, Judge.
So, thank you. All right. All right, sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes,
Thank you. Put your hand down. Do you, when you're not in lockup, reside on Large Street?
yes.
And who lives there with you?
That's the,
It's a shelter, Your
The
Honor.
shelter?
yeah.
Okay, do you have any other residents to go to?
909 East Jolly,
Who is that? What is that?
a friend of mine.
Okay.
Yeah.
All right. And I understand there's going to be a plea today?
Yes,
And are you a citizen?
yes.
Were you on probation, parole, or bond conditions on another file?
No,
What is the plea agreement on behalf of the people?
Yes, Your Honor, the plea would be for the defendant to plead to count 2 domestic violence, third offense notice. Upon successful plea and sentencing, count 1, the habitual 4th offender status shall be dismissed.
Full, fair, accurate, and complete?
Count 1 will also be dismissed, Your Honor. I don't know if the people said that.
Count 1 and habitual 4th?
I believe I did, but yes, count 1 would be dismissed as well as the habitual 4th.
Apologies, Judge.
That's okay. Full, fair, accurate, and complete?
Yes, Judge.
Sir, full, fair, accurate, and complete?
yes,
Counsel, you're waiving reading count 1 and habitual 4th?
We are.
And on behalf of the people, the victim was consulted?
The victim rights advocate, the victim's rights statute has been followed, Your Honor.
Thank you. You may proceed with reading the felony information.
Thank you, Your Honor. People of the State of Michigan versus Damon Edward Gullidge, State of Michigan, County of Ingham. In the name of the people of the State of Michigan, the prosecuting attorney for this county appears before the court and informs the court that on the date and at the location described below, the defendant in count 2, domestic violence and/or knowingly assaulting a pregnant individual, third offense notice. On or about April 17th, 2025, at 400 East Saginaw Street, Lansing, Michigan, 48912, Ingham County, State of Michigan, the defendant did make an assault or an assault and battery upon Erica Dawn Van Buren, an individual with whom he/she had a dating relationship, contrary to statute. Third offense notice. Take notice that the defendant has previously convicted of assaulting or assaulting and battering his spouse, former spouse, an individual with whom he had a dating relationship, an individual with whom he had a child in common, or a resident or former resident of his household, or of knowingly assaulting a pregnant individual by violating MCL 750.81 subsection 2 on or about July 1st of 1997 in the 54A District Court, County of Ingham, State of Michigan, and again by violating MCL 750.81 subsection 2 on or about September 10th, 2020 in the 54B District Court, County of Ingham, State of Michigan, and therefore, upon conviction, will be subject to an enhanced sentence under statute. There's potential restitution in this matter. This is a felony that's punishable up to a maximum of 5 years and/or $5,000. A consecutive sentence may be imposed under MCL 750.506A if the assault was committed in a place of confinement. Court shall order law enforcement to collect DNA identification profile sample before sentencing or disposition if not taken at the time of arrest and against the peace and dignity of the State of Michigan.
Sir, did you understand what was just read?
yes, I do.
So you understand count 2, domestic violence and/or knowingly assaulting a pregnant individual, third offense is punishable by 5 years. There's that enhancement to 5 years because the first is a 93-day, the second is a 1 year, and then the third goes up to 5 years. Do you understand that?
Yes, I do.
Looks like you signed the advice of rights form. Did you read it before you signed it?
Yes,
Did you understand what you read?
yes,
And if you had any questions, your attorney was able to answer those?
yes.
Have you taken any medication yesterday or today?
No,
Supposed to be on medication?
no,
Any sign of fever, COVID, or other illness?
no,
You made the decision to plead after you talked with your attorney?
yes,
You're pleading of your own free will?
yes,
You've been satisfied with your attorney?
yes,
As to count 2, domestic violence and/or knowingly assaulting a pregnant individual, third offense, how do you plead?
I plead guilty.
Do you understand that by pleading, you're giving up your automatic right of appeal? So now, if you wish to appeal, you first have to ask permission to appeal. You're also giving up presumption of innocence, the ability to cross-examine witnesses and evidence, to provide defense, to hold people to their burden of beyond a reasonable doubt.
Yes,
Has anyone told you what I will do at sentencing?
no,
And that's because I don't know. I will make up my mind at the time of sentencing, when I'm fully informed. I don't know much. I'm gonna learn a little bit today, but I won't be fully informed until sentencing. Do you understand that?
Yes,
And do you understand that you may have to pay restitution to make the victim whole for any personal or property damage? And if something is being requested that you disagree with, you just let your attorney know. We'll have a restitution hearing based on the evidence. I will make a ruling. That amount can go up, it also can go down. Do you understand that?
yes.
All right. I'm going to ask you some questions. Council may have additional questions for you. Did this offense occur on or about April 17th, 2025
Yes, it did.
in the city of Lansing County, of England, state of Michigan,
Yes,
at a specific location known as 400 East Saginaw Street?
yes,
And did you come in contact with Erica, ERICA, Dawn Van Buren, VANBUREN?
yes,
Did you have a dating relationship with her?
yes, I did.
Do you have any children in common?
No,
And were you living together or just dating or what?
just dating.
All right, and so on that date, April 17th, at 400 East Saginaw Street, did you and she have a disagreement or some kind of altercation? What happened?
Yeah, not shoved her out my way.
You shoved her out of your way. Was that done out of anger?
Yes,
And you put your hands on her?
yeah,
And you, did she sustain any injury?
no,
And you could have left without doing that, is that correct?
yes.
And on behalf of the people, any additional questions in regard to that, and then we'll get to the third.
No, Your Honor, people are satisfied.
All right,
Defense is satisfied, Judge. Thank you.
and sir, you would agree that this is the third time because there were two other charges of the same statute in that on or about July 1st, 1997, in the 54A District Court, and also on September 10th, 2020, in the 54B District Court, you were also convicted of the same charge of domestic violence in those courts.
Yes, I know.
Okay, all right. And you understand that's why there's that enhancement to the 5 years, correct?
Yes,
All right. On behalf of council, are you aware premises, threats, or inducements other than those already placed on the record?
No, Your Honor.
No, Judge.
Does court comply with court rule?
You have, Your Honor.
Yes, Judge.
I find defendant's plea has been freely voluntarily, knowingly, and understandingly made, without undue influence, threats, coercion, or promises of leniency. I also find there are sufficient grounds to accept defendant's plea. Therefore, count 2 will enter. Count 1 and the habitual fourth are hereby dismissed in their entirety. And any outstanding warrants, if any, related to this file are also recalled and dismissed. Is there a sentencing date?
April 8th at 10:30 a.m.
I think we set, let's make it 10:45, because I think we set something at 10:30, didn't we?
We said it for 10:15.
10:15. Oh, okay, 10:30 is fine. April 8th at 10:30. Does that meet with your schedule, council?
Yes, Judge. Thank you.
All right, sir, you need to cooperate with probation. They'll come and see you if you're released on bond. Are we talking about bond today?
No, Your Honor.
Okay, then probation is going to come and see you and they're going to do a very, or cooperate in their questions. They're going to do a very detailed pre-sentence investigation report that we're going to talk about at the time of sentencing. Do you understand?
yes, yes.
Okay, thank you. Anything else we need to address?
No, Your Honor. Thank
You
you.
getting what you need at the jail, sir?
No, I'm getting tormented. I'm messed up right now. I'm trying to maintain my composure. I've been at this 10 months right now. I'm being mentally tortured.
Well, what can I do? Can I get CMH in there? What do you need?
I don't know. Something's going on in there. It's not right. Something's
Tell me
going
what's
on.
going on with you, sir.
Huh?
Tell me what's going on with you.
I'm trying to get myself together. And
Okay, how can we help with that? Are you going to classes there?
I'm trying to stay out the way, but it's some evil going on in that jail and they letting it happen to me. I don't know what's going on in there. I'm hearing voices in the wall. There's
Okay,
all type of crazy stuff going on in there. I'm like,
Okay, I'm gonna order that, the jail have, physician and or community mental health meet with him and let's see what's going on. We're gonna have, someone that you can talk to, sir, okay?
And
Okay.
Judge, I'm just gonna make a brief record that in my conversation with him, he certainly seems oriented to time, date, and location. And I don't have any concerns about that.
He does with me too, but I imagine that it's difficult to be locked up, and so let's just get him some help over there while, so he's okay in the next, what, 4 or 5, 6 weeks before I see him again, okay?
Absolutely, Judge. Thank you.
All right. Things get worse, you'll let your attorney or me know, okay?
Okay.
Okay, thank you. Real thing.
I bet there's some.
This is docket 24458 FH.
458, you said?
Yes, 24458 FH. People of the state of Michigan versus Kyle William Kynes.
Ready.
This is a Judge Stokes case, and the court is handling an emergency, so I'm handling her matters for today.
Thank you, Your Honor.
Counsel, your appearances.
Angela Delver on behalf of the people.
Good afternoon, Your Honor. Christopher Coyle, P 49708, appearing on behalf of Kyle Kynes. Mr. Kynes, can you state your name for the record, please?
Kyle William Kynes.
Thank you. Please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
I do.
You can put your hand down. Sir, have you taken any medication yesterday or today? Are you supposed to take medication you're not on?
No.
Any sign of fever, COVID, or other illness?
No,
Have you had enough time to speak with your attorney?
I have.
And you understand this is a final pretrial?
I do.
And the final pretrial is held so that we can move your case forward. If you decided to plead, for example, I hear what you're gonna do in a minute, but if you decide to take a plea on the day of your jury trial, then someone else would lose their right to a jury trial. We only have so many days of the year. So final pretrials are held to then see where we are in the case and make sure that you and your attorney have time to prepare for jury trial. Do you understand?
I do.
All right, so it's not, it does force you, but it's not meant to force you in that way. It's meant to have you decide, so we all know how to prepare, and both sides have the opportunity to get to trial in a timely manner. Understand?
I do.
All right, very good. On behalf of the people, was there an offer, and if so, what is it?
The offer in this particular case, Your Honor, was that the people were willing to negotiate a plea bargain to any charge that resulted in public sex offender registration. It is my understanding that is the exact stipulation that the defendant is not willing to concede to.
So, Your Honor, for the record, I've discussed that with Mr. Kynes, and we are not prepared to accept that. And we wish to, well, we had a trial date set for March 17th, but I know that we're gonna, or I believe we're going to change that this afternoon.
For the record, Your Honor, just to supplement Mr. Coyle, we were set for trial in front of Judge Stokes on March 17th. There is a homicide that is an incarcerated defendant with an older case that is scheduled for trial. They had their last hearing today. There's no further plea offers. It's not going to be adjourned. Counsel of record is remaining on the case. So we did sit with Your Honor and Judge Stokes' docket prosecutor and agreed upon a new jury trial date of July 28th.
Agreed.
Full, fair, accurate, and complete?
Yes.
Full, fair, accurate, and complete?
Yes.
And you've had enough opportunity to consider the offer and the fact that the counteroffer wouldn't be accepted. And so it's your independent decision after consulting with counsel to decline the offer and go to jury trial.
It is, Your Honor.
Did anyone force, threaten, or coerce you to make this decision?
They have not.
Did anyone promise you anything that caused you to make this decision?
No.
You made this decision after consulting with counsel,
I have it.
and you've been satisfied with the representation of counsel.
I am.
Thank you. Jury trial is, I'm sorry, the 28th, July 28th. And I don't know, does Judge Stokes start hers at 8:30 or 9? I start mine at 9 because jurors don't come up until at least then. So 9 o'clock then, sir. July 28th, you'll be ready with your counsel. And if it changes again for any reason, certainly stay in contact with your attorney and he'll let you know. Meanwhile, bond conditions are continued and there'll be a continued no contact order, and you know what no contact means.
Certainly.
Is there anything else we need to?
Nothing further, Your Honor, from the people.
Nothing further from the defense.
Thank you, that's all for this record.
Thank you.
I need like a minute here.
Are you James McHenry next?
No, we're gonna finish the Judge Stokes.
This McHenry is so.
Yes.
Mark said it, so I
I just
didn't.
wanted to-
I'm not used to, didn't expect it to come
Okay.
apart.
What are we doing? We have
McHenry, James McHenry,
what's the problem?
March 17th.
No, but the new one.
July
Same day, same day.
It doesn't have a new trial date. I think that's what we're doing today.
Correct, we're setting that.
So you're gonna set all these for the 28th and then move them yet again? Is there another date?
We're not gonna set all of them, just these two, because defense counsel is on them. We understand that Kynes is the priority because it's the older case. But defense counsel and I actually had that conversation, should we set them for two different
We should
dates?
not. If they want a jury trial, we should not. We're just moving and moving and moving them. It's not fair to the victim, it's not fair to whatever, so find me a new date. Meanwhile, let me call the case. Are you ready, Nancy? I'm ready. This is docket 25-904 FC, people of the state of Michigan versus James Lee McHenry. Counsel, your appearance for the record.
Angela Dover on behalf of people.
Good afternoon, Your Honor. Christopher Coyle, P49708, appearing on behalf of James McHenry. Mr. McHenry, can you state your name for the record?
James Lee McHenry.
Please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes.
No, you put your hand down. Sir, have you taken any medication yesterday or today?
No.
Are you supposed to be on medication you're not on? Any sign of fever, cold, or other illness?
No, ma'am.
Have you had an opportunity to speak with your attorney?
Yes, ma'am.
And you understand this is a final pretrial?
Yes, ma'am.
And that's so we can keep your case moving, and if you were to accept a plea or want to do a plea on the day of trial, you'd be depriving someone else of their right to a trial, so we keep things moving in this way, you understand that?
Yes, ma'am.
And you're okay with that, you made a decision?
Yes, ma'am.
All right, on behalf of the people, was there an offer, and if so, what is it?
Yes, Your Honor, there was an offer in this case where the people would agree to amend the currently charged CSC first, which is currently charged as victim under 13, offender over 17 with a mandatory 25-year minimum. So the plea offer was to amend it to a different theory of CSC first to avoid the 25-year mandatory minimum, wherein we would then discuss a term of years, but the defendant is unwilling to plead to that particular charge, so.
Full, fair, accurate, and complete?
It is.
Full, fair, accurate, and complete?
Yes, ma'am.
And so you understand you will now start preparing for jury trial, or continue, I should hope,
Yes, ma'am.
preparing for jury trial with your attorney?
Yes, ma'am.
Did anyone force you or coerce you to make that decision?
No, ma'am.
Did anyone promise you anything that caused you to make that decision?
No, ma'am.
You made that decision of your own free will
Yes, ma'am.
after you discussed everything with your attorney?
Yes, ma'am.
And you've been satisfied with the representation of your attorney?
Yes, ma'am.
All right, so you will have a jury trial, what date?
So, Ms. Cisneros suggested either August 4th or September 9th. I'm available, or September 1st, I'm sorry. I'm available either of those dates, so I'll leave it to defense counsel. Kynes trials can be fairly short, so,
It was August 4th and the other,
9/1.
9/1, please.
Jury trial set for September 1st, 2026 at 9 a.m. Sir, you'll need to be here ready with your attorney. If for some reason the date changes, we'll let you know. Stay in contact with your attorney. Bond conditions are continued, and the contact order is continued. It doesn't appear there's been any problems. You understand what no contact means? It
Yes, ma'am.
doesn't live in your world anymore.
Yes, ma'am.
All right, anything else for the record?
No, Your Honor, thank you.
Okay, thank you. That is all for this record. The next one is Gonzalez.
They're bringing Mr. Gonzalez up from downstairs. We do have an interpreter on this case as well.
Oh, okay. I knew an interpreter came in around 1 o'clock or so. Probably. Do a sheet for me to sign to?
Yes, ma'am.
The approach.
What do you want me to say?
You can actually read first. Or I know you came earlier, were you here at like 12:30?
Not today, no.
What time did you come today?
Oh, 12:30 today, yes.
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 Stay probably because you may be there.
Okay.
Did I do it? No. And then I'll do this. Sorry.
Is there a trial date for this one?
Also set on March
No.
17th, but the new
May
one,
12th. The new one is May 12th.
May 12th.
This is docket 24482 FC, People of the State of Michigan versus Pascal Guzman Gonzalez. Counsel, your appearances?
Good afternoon, Your Honor. Jennifer Lawton on behalf of the people.
Good afternoon, Your Honor. Nicole Blake Becker on behalf of my client who stands to my right. You're ready to proceed.
Sir, please raise your right hand. Do you swear to translate from English to Spanish and from Spanish to English, everything that is stated on this case.
I do.
You may put your hand down, please state and spell your name.
Abner St. Giles, Abner Saint space Giles.
Thank you. Sir, have you taken any medication yesterday or today?
¿Está tomando medicamento hoy o mañana?
No.
Ayer? No.
Are you supposed to be on medication you're not on?
¿Usted está sometido a tomar medicamento?
No.
No.
Any sign of fever, COVID, or other illness?
¿Usted tiene algún signo de COVID, fiebre? No.
Have you had an opportunity to speak with your attorney?
¿Tiene oportunidad de hablar con tu abogado? ¿Tú hablas con abogado? ¿Tu abogado? Ella es tu abogado. Yes.
And you understand today is a final pretrial, so we can determine how this case is going to be resolved
Usted
through a
entiende
plea
que
or
hoy,
trial.
hoy es el prejuicio final, que usted entiende que vamos a determinar lo que pasa. Okay.
Sí.
Yes.
On behalf of the people, was there an offer made in this case?
Yes, Your,
Hay una oferta que hacen de parte del pueblo.
yes, Your Honor, the offer was to plead to count 3 and count 6.
La oferta era para llegar a el caso 3,
3 and 6.
3 y 6.
That is 2 counts of criminal sexual conduct in the second
Eran
degree.
dos cantos de abuso sexual.
The people would dismiss the balance.
Y el pueblo tiene que considerar los tiempos que ha pasado.
1, 2, 4, 5,
1, 2,
7,
4, 5, 7
and 8.
y 8.
Is that full, fair, accurate, and complete?
Yes.
¿Está de acuerdo?
Is that full, fair, accurate, and complete, sir?
¿Está de acuerdo? Completo. Los casos, los números de casos. Yes.
And counsel, will he be pleading today or will we be moving this to the trial docket?
¿Usted va a aceptar o hablando con el abogado si se va a aceptar o se va a conseguir?
We will be moving it to the trial docket.
Que vamos a seguir con el juicio.
Is he an American citizen?
¿Usted es americano?
No,
Has he had the opportunity to meet with an immigration lawyer?
¿Usted tiene la oportunidad de ver un abogado de inmigración? Sí. Yes, yes, Your Honor.
Sir, you decided to reject the plea offer, that's correct?
¿Usted no acepta la oferta? No acepta. No.
That's correct. You did, you do not want to accept the offer, is that correct?
No
Yes
acepta
or
la
no?
oferta.
No.
And you do not want to accept it, is that correct? Yes.
¿Está correcta que no acepta la oferta? Yes.
I rephrased it because when we read the transcript, it would read the wrong way. I just need to be clear.
Lo repita de nuevo porque a veces cuando lo leímos otra forma. Okay.
No. No acepto la.
I don't accept the offer.
Thank you.
Gracias.
And did anyone force, threaten, or coerce you to
Hay
reject
alguna
the
persona
offer?
que te hacen como decir que no o
No.
no.
Has anyone promised you anything that caused you
Te
to
han
reject the
hacer
offer?
promesa de otra cosa para que tú haces.
No.
You decided to reject the offer after you spoke with your attorney and considered all your options.
Usted está, usted se hace la respuesta después de hablar con tu abogado y conseguir con toda esa información que es necesaria. Yes.
and you've been satisfied with the representation of your attorney, is that
¿Usted
correct?
está satisfecho con tu abogada, con tu presentación? Sí. Yes.
Jury trial will be set for May 12th,
El juicio final
2026
va a ser el 12
at
de
9
mayo
a.m.
a las 9 de la mañana
in front of Judge Stokes.
al frente del juez Sos.
You'll need to continue to work with your attorney.
Usted tiene que seguir hablando con tu abogado, trabajando con tu abogado,
And there's a continued no contact order with the victim.
y todavía sigue sin contacto con las víctimas.
Are you getting what you need at the jail?
¿Usted está recibiendo lo que necesita en el cárcel?
Sí.
Yes.
Anything else for the record?
¿Otra cosa para el récord?
Not from the people.
No.
No, Your Honor, thank you.
Thank you, that's all for the record.
Gracias, eso es todo para hoy. Thank you.
Bart, who's next?
Scott.
I'm saying it for the deputy.
We're gonna go with Tyson Thomas.
Did you get that, Phil?
I did.
Sure.
Be $25, sir.
Just so you have the time. Everywhere.
It's get to. Maybe page 3, top 1.
Oh. This is docket 26-174 FC, People of the State of Michigan versus Tyson Robert Thomas. Counsel, your appearance for the record.
Assistant Prosecutor Abigail Tepper, P 84920, appearing on behalf of the people.
Good afternoon, Your Honor. Stephen A. Freeman, Public Defender, appearing on behalf of Mr. Tyson, who stands to my right.
Sir, please
Mr.
raise your
Thomas, I
right
beg your
hand.
pardon.
Do you swear or affirm the testimony you're about to provide me the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes, Your Honor.
Thank you. Put your hand down. And sir, have you taken any medication yesterday or today?
No, Your
Are
Honor.
you supposed to be on medication you're not on?
No, Your Honor.
Any sign of fever, COVID, or other illness?
No, Your Honor.
You've had enough time to talk with your attorney?
Yes, Your Honor.
All right. And counsel, this is a pretrial, was pretrial held?
It was, Your Honor, the people extended an offer to plead to count 4, unlawful imprisonment, count 5, resisting and obstructing police, count 6, interference with a crime report with a habitual offender notice. It's my understanding from defense counsel that the defendant wishes to reject this plea offer and will be continuing to trial.
Well, is this a final pretrial or do you want to just do that now? Counsel?
That's a correct statement, Your Honor, and I had discussed that with my client, and Our response is simply to thank you, respectfully reject the offer, and ask that the court place this case on its trial docket. Thank you.
So my question is, do you want a final pretrial about a month before the trial or not?
I would enjoy that, not necessarily because of an anticipated plea, but because there are always things, jury instructions and the like that we should address.
Well, we'll address all of that anyway, but I'm just, because we can treat this as a final pretrial, if he's certain he's not gonna change his mind, and then we can just move it along.
I don't believe it would be necessary then under those circumstances. Thank you.
All right, so what was stated is full, fair, accurate, and complete as plea offer? That would be pleading to, what was it, 4, 5, and 6?
Correct, Your Honor.
And then your balance would be dismissed 1, 2, and 3?
Yes.
Full, fair, accurate, and complete?
That I'm not accepting the plea deal.
Well, first of all, was the offer that she said that was conveyed to you that you would be pleading to 4, 5, and 6, and counts 1, 2, and 3 would be dismissed. That's the offer. You understand that?
Oh, yes, I understand that, Your Honor.
So that's full, fair, accurate, and complete.
Yes, Your Honor.
And you've decided to reject that and you want to go to jury trial.
Absolutely, Your Honor.
And did anyone force, threaten, or coerce you to make this decision?
No, Your Honor.
Did anyone promise you anything that caused you to make this decision?
No, Your Honor.
You made this decision of your own free will?
Absolutely, Your Honor.
And that's after you looked at the evidence, talked with your attorney, considered your options?
Yes, Your Honor.
All right, then we're gonna set this on the trial docket. Do we have a trial date?
Your Honor, I spoke to your docket attorney, Mr. Buxton, and he gave me a trial date of October 2nd.
October 2nd at 9 a.m. will be the jury trial unless something comes up. That looks like a good date, so we'll keep you posted. Does that look like a good date on your calendar, counsel?
It does, Your Honor. Thank you.
All right, so sir, you will need to prepare with your attorney for the jury trial. You have a few months to do that, so if there's anything special that you all need, he'll let us know and we'll get that evidence for you, or the witnesses or whatever. So you need to continue working with him. Do you understand?
Yes, Your Honor.
All right, anything else we need to address today?
Not from the people.
I have a motion to modify. Is that modify bond? I do have a bond report.
Thank you, Your Honor, as do we.
What would you like me to know, counsel?
Thank you very much, Your Honor. To be as succinct as I can be, the situation was that at the time my client was arraigned, the arraigning magistrate had before her, of course, a copy of the complaint, I believe a copy of his criminal record, and various information such that she took it upon herself to issue a $200,000 cash or surety bond based on those factors. We appear before the court today because we believe that those circumstances have changed. They have changed rather significantly in that the prosecutor's office is in receipt of an email from the complaining witness in this case. And I don't have it in front of me, but essentially recanting what she had indicated to the authorities on the date of this episode. That being the case, it strikes me that it would be a much steeper hill to climb for the prosecutor to show guilt beyond a reasonable doubt. And it is that concern that I have that would cause me to respectfully move the court to amend the bond from 200,000 cash surety to 50,000 cash surety. And in light of the fact that our trial date isn't until October, I would not want the bond at $200,000 continued and be viewed as punitive. Thank you.
Have you received a letter that recants the events?
Your Honor, the email was sent to Mr. Buxton and he did forward it on to me, so I have had a chance to review it. She does indicate in such email that the police report was not an entirely accurate account of events. Since she has sent this email, I have met with her in my office. She does not quote unquote wish to pursue criminal sexual conduct charges. She's concerned about how they may affect their children going forward. Did not recant those, did not recant the unlawful imprisonment. The interfering with a crime report was added with police testimony at the preliminary examination, and the resisting and obstructing is obviously the police, not my victim.
Is obviously the police not my victim, is that what you said?
Correct.
Thank you.
She did, again, come in and meet with me. She indicated to me that she's very frightened of the defendant. She wishes to move forward and have him held accountable, although she wishes that that would be without the criminal sexual conduct charges. Again, she did not recant those. She did express to me multiple times in my meeting with her and in my email sense that she's frightened of the defendant and wishes for him to stay in custody.
If I may,
Just a moment. So if you don't have did she testify to the CSC at trial or at preliminary exam?
She did not. She was present, but somebody covered that examination for me. She did not testify. It was based on the police statements.
So if this goes to trial and she's not on board, you have police officer assaulting, resisting, and interfering with crime report. Those would be the two viable ones based on the preliminary exam transcript?
Based on the preliminary exam transcript alone, however, she did indicate to me that she would honor a subpoena and would show up and testify. She just wishes not to proceed on the criminal sexual conduct charges if at all possible.
Has there been any interference that you're aware of?
Since he has been in custody, I know that there have been a number of phone calls with his family. I have not personally reviewed them all. I have asked for a detective to review them to see if there's continuing interference.
You know, sir, here's what I have to say. Normally, CSC charges where they're punishable by life, I'm not letting you out. But if I don't have a victim, I know she's scared, but all victims are scared of multiple things when there's been a trauma. I don't know what happened here, but it looks like the viability is on the people's case if she chooses to not testify. On the life offenses, the primary offense may be the felony of 20 years, which is home invasion, and if she doesn't show up or changes her mind, it will simply be a 2-year police officer and interfering with a crime report, which is a felony of 10 years. So I'm gonna give you a bond, but let me just say to you.
Yes, Your Honor.
If you have any contact with her whatsoever, directly, indirectly, or otherwise, there's no contact in my world means you don't get creative. No messages through carrier pigeon, smoke signal, email, AI, third parties, Hallmark cards, flowers, anonymous, anything. You see her in a McDonald's, you just leave. I don't care if you paid for your food and didn't receive it yet, you just get out of the building and you go to a different McDonald's. You're at the same Myers, you go to a different one. You're not gonna see your kids because she's got custody of them right now. You're not gonna see them. We can talk about that later. I don't know if she's filing for divorce and maybe we can work it out with the family court judge, or maybe you're filing for divorce. I do not know what happened here.
No, it wasn't. Oh, yes,
Sir, I don't know what happened here, but there'll be no contact. She simply doesn't exist in your world right now. If you violate, you're gonna be in that jumpsuit faster than you can say the word violate. Because I'm gonna have law enforcement give you an Uber ride to the hotel in Mason again and put you back in that jumpsuit until this is all resolved. Do you understand?
Yes, Your Honor.
Are you working?
Yes, Your Honor.
What do you do?
I'm a DoorDash driver.
You have a valid driver's license?
Yes, Your Honor.
And on behalf of the people, this felony information needs to be amended. Under victim or complainant, it has Sabrina Marie, I guess that would be his wife's name. But it also has Tyson Robert Thomas, unless that's a child's name.
They have a child of the same name as the defendant.
So are there any charges against that child?
He was a witness and did give the police a statement. There are no charges specific to the child, so I will remove him as a complainant.
He would be under, he should then be under the witness, and it looks like he is, so he shouldn't be under victim.
I will get an amended file, Your Honor.
Thank you. Do we have, oh, we do have, that's October 2nd, okay. You have a place to live, sir?
Yes, Your Honor.
Where?
My grandmother's home, 58.
Just a minute.
Yes, sir.
Okay, what is it, 58?
23 Durwell Drive, Lansing, Michigan.
Spell Durwell?
Yes, Your Honor. Durwell Drive.
Lansing,
Yes, Your Honor.
48911.
911.
And you're sure you can go there?
Absolutely, Your Honor.
So let me, so where does she live? She lives in Tisdale?
Yes, Your Honor.
Okay, so how far away is Tisdale from Durwell?
About 4 miles.
Okay, so you're not going to be within 1,000 feet of her.
Yes, Your Honor.
So you're DoorDash, don't be DoorDashing 1,000 feet, or you figure out your parameters there, because we're gonna have a GPS tether on you.
Absolutely.
And they do this crazy thing where one tire goes over for 1 minute and they want to benchmark you. Now, I don't always entertain those, but figure it out, so we don't even have to waste my time looking at those, because if you come within a distance of her where I think you're doing it to intimidate or harass or demean her, it's not accidental like those 1 minute tire drives that we keep having to respond to. I'm just putting you back in the jumpsuit. Have I been clear?
Understood, Your Honor.
Good, so get a map. I'm sure you probably know the city pretty well if you've been doing DoorDash.
Yes, Your Honor.
All right. I'm giving you $100,000 PR bond with a jail GPS teller. You will not be with the victim. It's gonna have victim notification, and you will not be within 1,000 feet of her school, residence, employment. You shall not use, possess, consume, or be in the presence of illegal drugs, alcohol, or drug paraphernalia. You'll show pretrial services, prescriptions for all medications from a licensed medical physician within 24 hours, and take any psychotropic medication if prescribed any as prescribed. You'll follow all doctor's recommendations. You will PBT and or drug test. It doesn't appear that you have a drug or alcohol problem, do you?
No, Your Honor.
So as requested by pretrial services, law enforcement, any court officer, or your grandmother. You shall, and let me just say, if, and counsel, you know this, if he is positive for anything, a secondary test will be done so we can see if it's a false positive or a positive, and then we'll deal with that when it arises, if it does. You will not own, have in your possession, under your control, a weapon, gun, ammunition, or imitation of a weapon. You'll not be in the presence of anyone who has those items. You'll not be in the presence of any known gang members, wear any gang colors, insignia, or gang tattoos. You will maintain that residence at your grandmother's home. You will not change it without permission of this court.
Yes, Your Honor.
You will appear for all hearings and proceedings. The next hearing is the jury trial, October 2nd at 9 a.m. You'll also appear for any other hearings we may have. Council may need to meet with me to figure out motions or anything else you might be entitled to. I don't know. And so when the trial date could change, so you need to stay in contact with your attorney and appear for all those hearings and proceedings, regardless of whether it's the jury trial date, anything before or after.
Yes, Your Honor.
Is there anything else I need to order?
Your Honor, I apologize. I did receive the bond recommendation evaluation while you were speaking. It does appear the defendant had 2 prior failure to appears and was on pretrial release for 2 misdemeanor traffic matters. I just wanted to make sure that was
2 misdemeanor
traffic matters.
Yep, I saw a traffic matter, oh well.
I just wanted to ensure that the record was clear, that he does have prior failures to appear.
All right, I've been clear with him, because if he doesn't show up, there'll be no more bond, there'll be nothing, he's just going to sit in the jail. And that might put your trial back farther, so it'll take a long time to resolve this and a longer time where you're not seeing your children.
Yes, Your Honor.
So let's get to the bottom of all this, follow my orders, otherwise, I don't play jokes, I'm not a very funny person. Ask any of the attorneys. You violate, I end up with multiple files or violations. We got the Mason jail. The sheriff likes to clean it out once in a while, so I accommodate your needs and his. But I gotta work hard to keep you. I just keep you in that jumpsuit. If you decide if you want to be a free man who works and gets past this, or a jailed man,
Yes, Your
it's
Honor.
up to you. Got it?
Understood.
I don't know about those traffic things that happens to a lot of people. They don't get notices, they forget, it's not a really big kind of thing. I was a district judge, I saw a lot of that. But sir, these are very, very, very serious. You better be the best citizen we have. Have I made myself clear, counsel?
You certainly have, Your Honor, except for how often you'd like the defendant to report to pretrial.
As directed, so it can be weekly, monthly, bi-weekly, let's have them meet and figure it out. So you, as soon as you get out of jail, you got 24 hours to go report to pretrial services, they're in our basement, I believe. You go figure that out, okay?
My thanks to the court.
Thank you, we're gonna get you copies of this.
Thank you, Your Honor.
And sir, there is an indigent tether. So if you can't afford the tether, you just provide proof of that. And you won't have to pay for it. You
Yes.
can talk to your attorney about that.
Yes, Your Honor.
And the public defender's office has a social worker, we can also help you with that, so.
Thank you, Your Honor.
May council I approach on the Hutchins matter for a moment?
Yes.
That's who this guy, that's who he's trying to steal your paperwork.
Thank you, sir.
He was trying to steal it, Bill.
So we just handled it like a we got we don't have to keep the last thing is on the record.
Yeah.
I think
That's what I was about to say.
do you want to go on the Zoom and go and ask him to explain for some percent? But I can decide if I need to. He's right there. He's right there. Otherwise, we don't really want that.
You're gonna go private Zoom?
You want to do the conference and then break up?
Breakout room for forensics.
We're gonna keep him there until his court days. I'm reading him for his court days. He's there on maintenance order.
Just put them in a Zoom room, please.
Yep, we'll do.
And then after that, we're not gonna go on the record on it.
As soon as Jared logged on.
Okay.
Thank you.
You're a little slow.
You wanna do that?
Are you doing yours?
I'll go back.
Aren't you asking?
No, I know that. I know. Okay, that's what I was. Read.
No. There's pros and cons.
Yeah.
Okay.
So how much more?
Yeah, he doesn't want to.
Okay. I don't know.
What's next?
I'm Nancy and I are just sitting here.
I'm so confused. It's like the.
Okay, so Brady Tyler, Wallace next.
All right.
Oh, I know this one.
You do? Yeah, it's done. This just looks like, how many more do we have?
Probably 20. Maybe not that many, but like 8.
Oh. This is docket, are you ready? And Wallace?
Go ahead.
This is docket 24769FH, People of State of Michigan versus Tyler Wallace. Counsel, your appearance for the record.
Good afternoon, Your Honor. AP Burt Buxton on behalf of the people of the state of Michigan.
Agent Stephen Grant on behalf of probation. And Luke Goodrich from the Public Defender's Office, here to represent Mr. Wallace, who's standing to my right.
Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes.
Thank you. Put your hand down. Have you taken any medication yesterday or today?
No.
Are you supposed to be on medication you're not on?
Yes.
And does that interfere with your ability to understand the court or your attorney?
No, not today.
And you're feeling okay today?
Yes.
All right. Any sign of fever, COVID, or other illness?
No.
Have you had an opportunity to speak with Mr. Goodrich?
Yes.
Mr. Goodrich, do you believe he's oriented to date, time, and place and does understand what's occurring today?
Yes, Your Honor.
Thank you. Sir, you pled no contest to count 1, weapons, firearms, possession by felon with habitual. Second, it was punishable by 7 years. I have a probation violation. Counsel, have you reviewed that with your client?
Yes, I have, Your Honor.
All right. Are there any amendments?
No, Your Honor.
Thank you. Sir, I have this probation violation, a request for a bench warrant that the court signed. And I signed that on January 22nd. It alleges the following. Count one, on or about January 15, 2026, or any date thereafter, defendant failed to report to probation. Count two, on or about January 6, 2026, defendant violated a personal protection order. Are there charges stemming from that?
I believe there's
I have court on the sixth.
a personal protection order hearing downstairs.
All right, so that one's going to be held in abeyance. All right, so the only one we can deal with today is January 15, 2026, failure to report to probation, and anytime thereafter.
Yeah, he intends to plead guilty to that.
Is that correct, sir?
Yes,
All right, you understand the violation?
I do.
All right, and you're pleading of your own free will?
Yes.
After you discussed everything with your attorney?
Yes.
And you've been satisfied with the representation, Mr. Goodrich? Have you been satisfied?
Yes. Sorry, I thought you
Sir?
were asking him a question.
As to count one, on or about January 15th, 2026, or any day thereafter, failure to report to probation, how do you plead?
Guilty.
Did anyone force, threaten, or coerce you to plead?
No.
Anyone promise you anything that caused you to plead?
No.
You understood you needed to show up each and every time probation wanted you to, and if something came up, I believe I advised you, and if not, they probably advised you that you just need to reschedule, let them know where you're at, and you failed to do that, so we had
I
eventually
didn't have a phone at the time. I apologize.
Questions, yes or no?
Yes, I understand.
All right, I find defendant's plea has been freely, voluntarily, knowingly, and understandingly made. He is now in contempt of court. Count one will enter. Let me just turn to you, sir. You started to say you didn't have a phone at the time?
Yeah.
Well,
And
you
pretty
got-
much, I was going through a lot of mental health stuff, so I just kind of gave up really, so,
Were you not on your meds?
no.
But you're on your meds now.
I haven't taken them since I've been here, but yes, I am.
Why aren't you taking them?
Because the jail doesn't have my meds, and my meds are pretty much at home.
Where are your meds?
At home.
Is there someone there that can bring them to you?
No. My grandpa, they're pretty much in my grandpa's house, really. That's where I've been staying at, and he's 83 years old, so he doesn't drive anymore.
Okay. All right. What's the recommendation of probation?
Thank you, Your Honor. The recommendation for probation is going to be adopting the 365 days that were held in advance with credit for 7 days served. It should also be noted that his discharge date for this was actually February 13th of 2026, Your Honor.
I did want to ask.
Wait a minute, February 13th of 2026?
Yes, Your Honor.
Well, then we're done.
Well, I believe the warrant went out in January. It's,
Oh.
Yeah, this is the warrant is from
Okay.
January.
Oh, okay, I got you, okay. All right, well, that's when I signed it, so, all right. How many days jail does he have?
As of right now, Your Honor, he has 7 days for this current arrest.
Plus what?
Nothing.
You didn't have any on the original?
No, I served time in Boone County for my other stuff over there.
yeah, he
How much
was,
time did you serve there?
7 months, 6 months. And I'd really like to continue doing probation so I can do better, because I have just a lot going on.
Yeah, we just lose jurisdiction. I could extend probation, but, sir, do you need help? What's the story with you? Are you working with community mental health?
Yes, a little bit, but then, I mean, with my relationship issues and everything else, where I did kind of just give up.
What do you mean relationship issues?
With kind of how there's the PPO, it's with her mom, and I'm dating the daughter I was, but there was those issues, and then just other issues, like my mom's dying, and then my little brother's in foster care, so just have a lot going on right now.
Okay, let's
I
take
kinda-
them one at a time. You got a girlfriend, but you don't like the mother.
The mother doesn't like me,
Okay,
but she was my girlfriend, she broke up with me since then, but
great. Is she out of your life?
that's why I'm trying to actually get my life back on track.
Okay, here's the thing. When you date someone, and especially if you marry them, you get the whole kit and caboodle. It doesn't matter who you like and who you don't. They're all in your life. So if someone doesn't like you, just say goodbye to the other person. The world is filled with people you can date.
I understand that.
Okay. And you gotta stay in your medicine so that you're thinking right and you can make those
I
decisions,
understand that. A
right?
couple weeks ago, I actually did go to the crisis center, and that's when I got put back on my meds.
So you're making better choices.
And
Okay, are you working?
somewhat, but.
Well, what's
it's kinda-
somewhat? Either,
it
that's
was-
kind of like being a
It was
little
like,
bit
it was
pregnant.
under the table, it wasn't,
No, no, we don't say that here because that's a federal and state
Okay.
crime. So you're getting paid as an independent contractor. I hope you're gonna pay taxes on that. So you do
Yeah.
work. So what do, sir?
I was painting.
Painting, great. Okay, you got some skills. Okay, has he completed anything on probation?
Your Honor, he has not. I've received an email from MMRS, which he was referred to complete CBT. They indicated that he completed his intake assessment on 12/31/2025 and enrolled in 4 p.m. CBT group with a start date of 1/6/2026. However, has not attended any group session. And they were informed on 1/31/2026 by Agent Bean, who is his primary agent, that he had absconded.
Okay, so let me just talk to you about, you were in, what'd you say, Eaton County for 8 months? Is that a yes?
Yes.
7, 8 months?
Yes.
Okay. So I'm familiar with Eaton County. I used to practice in all these counties. So Eaton County has a whole bunch of really good programs there. Did you participate and complete anything?
No, there they weren't. My supervision was here, so I didn't know.
I mean, while you were in custody.
While I was in custody, no, I don't believe I did. I was doing the GD program and stuff like that or whatever, like classes like that, but other than that, no, I wasn't.
Did you get that completed in the Eaton County Jail or?
No, pretty much they didn't do it there. They said when I got out, I was supposed to do it, but I got out the same month that they were taking that classes and stuff, so I never got to, so I have to go back and do so.
Okay, so let me understand the rest of the story. Your mother is ill?
Yeah, she has congestive heart failure and she's in a wheelchair, kind of in like a rehab facility right now, so
How old is she?
like 50, 51.
Wow, that's horrible. And what else is going on?
My 9-year-old brother's in foster care and has been for almost a year. And pretty much it's to the point where they're about to like, we have to get him back now or he's gonna be in the system.
Well, sir, how are you gonna do that when you're in jail and when you've got all this criminal stuff going on?
I didn't plan to go in jail. My grandpa was gonna help me pretty much get back on my feet. And that was gonna be the place I was gonna try and get my little brother to, because they were gonna give me the opportunity to have custody of him, so.
So you're gonna live with your grandfather and the two of you are gonna raise your little brother?
Well, I was going to, and to help take care of my grandpa also.
Yeah? What other family you got?
Just him and my mom, pretty much, my stepdad, he's not in the picture, my real father passed away.
Okay. So taking care of a 9-year-old is a lot of work.
Yeah,
You think you're gonna be able to stay on your medicine and do all that?
yeah, I have a 10-year-old and a 10-year-old and a 6-year-old myself, so.
So are you seeing them?
I haven't seen either of them in a couple months, no.
Why?
Kind of issues with the mom and girlfriend, ex-girlfriend.
Are you telling me that the mom that doesn't like you is the grandmother of your children?
One of them, yeah. So I kind of just gave up and just said screw everything, because I kind of just, everything just went
Do
bad.
you have custody orders with the family court?
No, it's something I need to do, but I need to get everything in order with this, that way I can actually go do that.
Have you ever received an award? Well, you just got one today. I'm giving you the award for the most excuses of the day.
No, I'm not trying to make excuses, it's
We
just,
are, sir. Let me just tell you a couple of things. You have a constitution, why don't you look at me? You have a constitution protected right to raise your children. You're the one that needs to step up to the plate, go to the family division downstairs and say, I want to raise my children. Those children are entitled to child support. It's a right and entitlement of the child and an obligation of the parents
I'm trying to do
to
everything. I
pay
can.
child support. Interrupt me and we'll continue this in 93 days.
Oh.
You didn't try nothing because I don't have any papers here saying there's any case open there where you're filing for custody and paying support. And you're getting paid unlawfully. You better get a 1099. Claim whatever wages and show in front of the court that you are capable of having money, earning money, raising your brother and your children. It doesn't even begin to scratch the surface of what you have in front of me with all these guns. Do you think that you're gonna get custody of children? The number one killer of children is guns. And now I know you only pled to one, but I got for 18 counts of felony firearm and 18 counts with habitual second. You are lucky you're not in prison.
I understand.
At what point are you gonna get your life in line?
I'm hoping to now.
Uh,
I realize that I'm too old to pretty much be doing this and going back and forth. I realize a lot of it has been relationship issues, and like you just said, there's lots of people out there, and I just now realized that at damn near 30 years old, that there's other people out there, and I don't need to just be stuck on one, so.
exactly. There are people that would make you happy instead of miserable and in the jumpsuit. But you got choices to make, sir. So here's the thing. If you want to see your children, you need to file with the friend of the court and with the family court judge and get some joint custody, parenting time, whatever it is. But you need to be law abiding, and you need to work, and you need to be appropriate, and you need to take some parenting classes, and you need to petition the probate court for your brother or child protective services or whatever, and do all that.
CPS is, that's what they were talking about, is giving me custody pretty much, but they needed access.
Yeah, they're gonna.
See that I could take care of them, so.
Yeah, they do a lot of talking. They're gonna do a lot of walking the other way as soon as you don't show up. This state is harsh on parental termination. I did 20 years of that kind of work as a lawyer. I represented people like you. I represented kids. I represented grandparents. It didn't matter. You gotta be good every step of the way because the state does not care. What they want is a fit parent.
2024, they give me temporary custody of them, but then in the end of 2024, I kind of got shot in the head, so like, that's why I've been having a lot of mental issues too, or whatever.
Okay.
So like, I'm trying to get everything taken care of.
Yeah, so in 2023, we had these charges in your file. And you kind of didn't get the message. So playing with guns and people with guns, you get shot in the head.
I
Sir.
don't like guns, pretty much. These are all the
All right.
extra guns.
Well, your record says otherwise, so let me just see.
Or mine, I was never even called.
How long did I have him on probation?
Just 6 months, Your Honor. So we
All right.
would ask the court to consider just extending that.
This allowed you to leave the state to drive, to be a truck driver. Did you lie to me? Were you driving a truck?
I was at one point, but I didn't do so because you said you needed an actual schedule, and that's what my probation officer was going on with. He needed an actual schedule of when I would be in town and when I wouldn't, and it would change. So I
It
never
doesn't matter
actually.
if it changes every day. You just fax the schedule. Do you know how many people are? We have lots of truck drivers. It's a good job.
So that's why I didn't pursue that, and that's why I went with paying.
That's another shitty excuse. Again, number one excuse maker of the day. Look it, sir. You take your schedule and you have your employer fax it, or you take a
Okay.
screenshot of it and you send it over to your probation agent. Not hard. We just need to know where you are because we have compacts and the other states will yell at us and they'll say no more. And there's all sorts of other reasons that government does that I'm not in charge of the world, so I can't control that. I can control what you do and how you comply. Take a screenshot, give it, they say, okay, we're good. We just need to keep track of you.
Good.
It's
I
not
didn't
hard.
understand that at the time, I guess. I'm sorry.
If you show up to probation, they explain it to you. And if they don't understand, they can call me 24/7 and guess what? I pick up the phone.
Okay.
So here's what we're doing. We're doing 5 years probation. He's going to comply with family court orders, personal protection orders, child protective services orders. He's going to remain residing with his father. He's going to take parenting classes because if he's going to get custody, he's going to need them. He is going to follow everything on CPS, whatever they have him do become orders of this court. He doesn't have to do duplicate. And we can amend it as reasonable so we don't overwhelm him. But sir, it appears you need some help being successful and putting your family together. Well, that's what probation is for. Now, if you decide that you're tired of all this, you just let me know. I can send you to jail or prison. And technically, it's only 3 years probation I can do, I think, right?
That's correct.
All right, so do the 3, but 5's not out of the question because if you violate again, I may make it 5 and I may send you to prison. Got it?
Got it.
But I said 5 so you know how serious I am. Get
Thank you.
serious about your family and your kids and straightening up.
In December, I did text my probation officer and I called him a couple times because I did ask for help because I was wanting to get back on track and do what I needed to do, so. At least for the last 2 months, I have been wanting to do better, so thank you for the chance.
A lot of people want, I deal in evidence. Show me the evidence, sir. I'll be jumping for joy when I sign a successful release from probation. You got 7 days of credit for 7 days, but you get 365 credit for 7. The balance is held. Make no mistake, I will use any or all of that as needed. You understand, sir?
Yes, I understand. And for my probation in Eaton County, how is that gonna go about? Still just the same as
We
it
can
was?
transfer it, but you first have to, is it transferred?
If supervision was here, but I don't understand how that's going either.
Well, you first have to show up and tell us that's a problem. Is he living in Eaton County?
He is currently living in Ingham County, to my knowledge. Speaking with his agents over there, he may have, they were speaking about possibly having TI or a transfer back to Eaton County for supervision. His case is here and he has a separate case in Eaton County.
Well,
Currently
is
living in
Eaton
Eaton.
County, are you supervising for Eaton too?
No, Your Honor. We're only supervising him for, oh yes, I apologize. Yes, we're supervising him for both Ingham and Eaton.
So you're living in Ingham, why do you want to go to Eaton?
I was just asking how that's going about. Is it still gonna be continue the same supervision here for both?
Yes,
Okay.
yes. Don't mess up, sir.
Your Honor, one thing I did want to clarify, just for people taking notes, I believe you said you were ordered him to reside with his father. and I
I'm
think you
sorry,
meant
my
his
grandfather. I did mean his grandfather, yes. He can't reside with his dad. His dad is no longer with us. He's with God, so.
And also, so the court and probation are aware he does have a hold for Eaton County, and we'll have to address that first before getting back started on it.
That's kind of why I asked how that's going about, if they were gonna be
Well,
two separate.
she can't tell Eaton County what to
I
do.
can't tell them what to do. I don't know. I just know we're gonna try to help you out.
Thank you.
Hopefully they'll listen to what I did and give you another chance. You got a lot of things going on, sir, but you know what? Probation is your friend. They're not your enemy. This is to set you up for success. Jail and prison is the downside. Probation's a good thing. Show up, ask for help, show us what you've done. Continue your education, get your kids and your family and your life in order. Before you know it, you're gonna be 90 and reflect on what did I do with my life?
I don't want that.
When you think about how you're gonna explain that to your dad, to God, I don't know, that's not gonna be a fun conversation, is it? So let's have a conversation you can be proud of. It's okay to make mistakes, it's what you do with them. You gotta learn from them. So here's your blue light special and your award for today.
Thank you.
Get on it, sir.
Thank you,
That's
Your
all
Honor.
for the record.
It is student.
Thank you.
We need Luke Major next.
Yeah.
Oh, that was the one, yeah.
Was Aaron Robinson.
If it's not too much work.
Forgot about
Well, once I saw the charges, I was like,
This one. I'll do my best.
are you sure?
that. Oh my gosh, what are we doing?
I remember it.
Is this a plea?
Yes, it is, Your Honor.
Oh, yeah. Did Milks get the plea or did you?
I'm doing.
No, but did Milks talk to you about the plea?
So
Who
is this-
negotiated?
Is this now your case? Because why did I have?
No, Steve is just out today.
Oh,
I apologize. I was told that Steve Feigelson was handling it this morning, and I guess
that's okay.
things changed.
Yeah. Get to wake that one up.
Judge, can I approach?
Yes, you can.
I don't have it yet. Yeah, I know it's bad, and I think.
That's why I said, now I remember, that's why I was like, oh, now I remember for sure.
Oh, no,
Is this one?
Because at first he wasn't gonna.
I did it right now.
Right? All right, this is docket 22613 FH, 2324 FH, and 2532 FH. People of the state of Michigan versus Luke Major. Counsel, your appearance for the record.
Good afternoon, Your Honor. APA Bart Buxton on behalf of the people of the state of Michigan.
And thank you, Your Honor. Jonathan Foreman, Office of the Public Defender, here with Mr. Major, who is standing to my right. I'm standing in today for Steve Milks on the 23 and 22 files, and for Brian Jackson on the 25 file.
Thank you. Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth and the whole perjury?
Yes, Your Honor.
Thank you. Put your hand down. Sir, you're entitled to, I understand there's going to be a plea today.
Yes, ma'am.
You're entitled to the same attorney for plea and sentencing. Would you like that, or is it okay that we have all these different attorneys?
Whatever's easiest for the court, Your Honor.
Doesn't matter to me. It's totally up to you. It's not easier one way or the other. I know the council would be more than happy to be here for sentencing.
Oh, yeah.
Well, I'll work it out with Mr. Milks.
Great. And Mr. Jackson.
Certainly with Mr. Jackson, Judge.
Great. You are now attorney of record on all three.
Congratulations.
Thank you. All right. And sir, do you reside, let me see, I have a number of, you have a residence?
My
Homeless?
sister's, yeah, my sister's present.
I provided an address on the forms to the court, Your Honor. It's a Leslie address.
It's coming.
Okay.
And it was 108 Worthington.
Worthington. Worthington Place. It's an apartment building, Worthington Place.
Worthington?
Yeah. Leslie.
All right. Okay, so I do have the address, and that's 108 Worthington, Leslie, Michigan,
Yep.
49251, and that's your sister's?
Yes,
And
ma'am.
you can reside there?
Yes, ma'am.
Who else is in the home?
My niece, her daughter, which she's 18, she just graduated high school last.
Okay, very good. And are you a US citizen?
Yes, ma'am.
And do you work?
I'm a union carpenter, but I haven't worked for some time, so I've been incarcerated.
Okay, but you can go back to, there's a huge demand for carpentry.
Yeah, there is.
Okay,
So that's what I'm planning on doing after I get situated and get residence of my own. What I plan on going back to, so.
well, you don't need a residence of your own. You gotta make some money to get that residence, so why can't you go back to work?
I could, my sister's gonna be in Leslie, and then I'm talking about going to treatment, so it would obviously
Okay.
be after that.
Yeah, of course.
But
All
I
right.
definitely need to be back to work. I got a child.
Were you
4-year-old
on
child.
probation, parole, or bond at the time of the event you're pleading to?
No, Your Honor.
How old is your child?
4 years old,
Have
5
you,
in July.
have you taken any medication yesterday or today?
But then I'm prescribed, yes.
Okay, and does it interfere with your ability to understand your attorney or the court?
No, Your
Is
Honor.
there medication you're supposed to be on that you're not on?
No, Your Honor.
Any sign of fever, COVID, or other illness?
No, Your
You've
Honor.
had enough time to talk with your attorney?
Yes, Your
And
Honor.
there's going to be a plea today?
Yes, Your
And you're
Honor.
making that of your own free will?
Yes, Your Honor.
And you have decided to plead after consulting with your attorney?
Yes, Your Honor.
And I know you've had multiple attorneys, but you've been satisfied with all of them. However, you would like this attorney to stay because you have a good rapport with him, is that correct?
Yes, Your Honor.
And you've been satisfied with his representation of you as well as your discussions in regard to the plea?
Absolutely.
All right. And what is the plea agreement?
Yes, Your Honor, the defendant will be pleading, so this is a global resolution. Defendant will be pleading in 25-3278 FH to count 1, possession of methamphetamine. Upon successful plea and sentencing, the habitual fourth offender status in that file, as well as 22-613 FH and 23-24 FH will be dismissed in their entirety. There is also an agreement that the defendant must complete a term of probation that will include residential treatment.
And the drug of choice was meth?
Heroin and meth.
Okay, so I will put you, once you plead, you are eligible to then go to treatment. So you'll be in a heroin, meth, the best specific treatment program for those drugs. Is that okay with you?
Thank you, Your Honor.
And you'll have to complete all terms and conditions of that probation, including any aftercare. If you fail to do that, I'll just get you treated in jail or prison. You understand that?
Yes, Your Honor.
Okay, great. Is that full, fair, accurate, and complete?
Yes, Judge.
Full, fair, accurate, and complete?
Yes, Your Honor.
On behalf of the people, is there any restitution on the property crimes or to any buy monies or anything like that that's due?
I don't believe so at this time, Your Honor.
Okay. All right. And counsel, you're waiving reading the habitual fourth on docket 25-3278 FH, as well as reading in its entirety both docket 22-613 FH and 23-24 FH.
Yes, Judge.
As to the reading of the felony information.
Thank you, Your Honor. People of the State of Michigan versus Luke Andrew Major. People, the State of Michigan, County of Ingham, in the name of the people of the State of Michigan, the prosecuting attorney appears before this court and informs the court that on the date and the location described below, the defendant in count 1, controlled substance possession of methamphetamine. On or about April 7, 2024, at 2320 Wood Street, Lansing Township, Ingham County, State of Michigan, the defendant did knowingly or intentionally possess methamphetamine contrary to statute. This is a felony that is punishable by up to a maximum of 10 years and or $15,000. Court shall order law enforcement to collect a DNA identification profile sample for sentencing or disposition if not taken at a time of arrest and against the peace and dignity of the State of Michigan.
Sir, did you understand what was just read?
Yes, Your Honor.
So you understand count 1, controlled substance possession of a controlled substance known as methamphetamine/ecstasy is a felony punishable by 10 years and or $15,000.
Yes, Your Honor.
Did they take your DNA or was it already on file?
It was already on file.
All right, thank you. And it looks like you signed the advice of rights form. Did you read it before you signed it?
Yes, Your Honor.
Did you understand what you read?
Yes, Your Honor.
And if you had any questions, was your attorney able to answer those?
Yes, Your Honor.
Do you have any questions about your rights at this court?
No, I'm not, Your Honor.
Sir, as to count 1 on docket 25-3278 FH, controlled substance possession of a controlled substance known as methamphetamine/ecstasy, how do you plead?
Guilty, Your Honor.
Did anyone force, threaten, or coerce you to plead?
No, Your Honor.
Anyone promise you anything that caused you to plead?
No, Your Honor.
You pled of your own free will
Yes, Your Honor.
after discussing everything with your attorney,
Yes, Your Honor.
and you remain satisfied with your attorney?
Yes, I do, Your Honor.
And sir, you understand that by pleading, you're giving up certain rights and defenses you would have had you had a bench trial or jury trial, such as the presumption of innocence, the ability to cross-examine witnesses and evidence, the ability to hold the people to their burden beyond reasonable doubt, the ability to remain silent and not have it count against you, as well as an automatic right of appeal. Now, if you choose to appeal, you would first have to ask permission of the Court of Appeals to appeal. And they may or may not agree with the importance of your issues, and they don't have to agree with it. Do you understand?
Yes, Your Honor.
All right. And sir, has anyone told you what I will do at the time of sentencing?
No, Your Honor.
And that's because I don't know. I will know at the time of sentencing. When I'm fully informed, I'll make a decision. Do you understand that?
Yes, Your Honor.
And there is a recommendation for treatment. And I'm going to follow that as well as term of probation. Now, if I don't follow that and I, for example, send you to prison, I would allow you to withdraw your plea. And then this would go back to the pretrial stage. However, if you violate the law or bond conditions, I don't have to follow the recommendation and I don't have to allow you to withdraw your plea. Do you understand how that works?
Yes, Your Honor.
All right, very good. Sir, did this event occur on or about April 7th, 2024?
Yes, Your Honor.
In the township of Lansing County of Ingham, State of Michigan,
Yes, Your Honor.
at a specific location known as 2320 Wood Street.
Yes, Your
You
Honor.
came in contact with law enforcement.
Yes, Your Honor.
Did they come to your home or were you outside of that residence?
I was outside of the residence. It was on the
And
street.
why did they approach you, law enforcement?
Because the police been called saying that suspicious people were at an address.
And that included you?
Yes.
They were doing a safety check,
I
investigating the
so.
complaint?
Yes,
And when they came in contact with you, were you high?
I was.
And did that then cause them to search you or to ask you about that?
Yes, they asked for my identification, which time yeah,
And then did they find methamphetamine on your person?
yes, they did. Your
Where was it
Honor.
located?
In my right pocket.
All right, and you were high, are you remembering this from your own memory? or-
Yeah, I remember it was pretty traumatizing.
Okay, all right. And counsel, if there's any defect in the search, doesn't sound like there is, that's being waived.
Yes, Judge, and can I just ask one more clarifying question? Mr. Major, you had warrants out, that's why they
Yeah,
arrested you, correct?
yes.
Okay, thank you. And sir, you didn't have any license, special authority or permission, prescription to have the meth, is that correct?
That is correct, Your Honor.
And you knew it was unlawful for you to intentionally possess it, correct?
Correct, Your Honor.
And you did in fact knowingly and intentionally use it, possess it, and put it in your pocket and your body.
Correct, yeah.
All right, on behalf of the people, any additional questions?
People are satisfied, Your Honor.
Can I just ask that, Judge?
Thank you. Our counsel, where promises, threats, or inducements other than those placed on the record?
No, Your Honor.
No, Judge.
Ms. Clerk, comply with the court rule?
You have, Your Honor.
Yes, Judge.
I find defendant's plea has been freely, voluntarily, knowingly, and understandingly made without undue influence, threats, coercion, or promises of leniency. I also find there sufficient grounds to accept defendant's plea. Therefore, count one will enter on docket 25-3278 FH. The habitual offender for offense notice is hereby dismissed. Also dismissed in their entirety is docket 22613 FH and 2324 FH. If there is any restitution, then that will be addressed on this docket that remains open. And that restitution looks like it might be on the receiving and concealing the motor vehicle, but I don't know. So we'll talk about any restitution. If you disagree with the amount, sir, we'll have a hearing on it and I'll make that determination. All weapons and contraband, if any, drugs seized, are hereby forfeited. Any outstanding warrants on all three files are hereby recalled and dismissed. Do we have a sentencing date?
April 8th at 11 a.m.
Does that meet with your schedule, counsel?
Yes, Judge, thank you.
Thank you. Sir, probation is going to come and see you, and they're going to be doing a very detailed pre-sentence investigation report that we will talk about at the time of sentencing. I will give you a PR bond upon acceptance into a long-term residential treatment program that is specific to meth and heroin. And then you will need to report to probation or pretrial services, as the case may be, within 24 hours of your release. It is likely that we will be sentencing you while you're in there. You can be here on Zoom unless you want us to bring you here personally. I don't know if you'll still be in residential or not.
Okay.
Okay, so I'd like to hear in person if you're out of treatment, but if you're in treatment, they can put you on Zoom.
Oh, yes, Your Honor.
Okay,
And Judge, he has been working with CATS. It's my information that there is a bed available for him at Holden House. So hopefully that'll happen sooner rather than later.
okay, so sir, if you walk out of treatment, if you misbehave in treatment, you may very well be walking into prison.
Yes, Your Honor. I don't plan on screwing up this time.
Very good. Anything else for the record?
No, Your Honor, thank you.
No, Your Honor, thank you.
Thank you.
Thank you, Your Honor. We got to get close.
We've got Christopher Gordy next.
We're waiting for the victim's mom to get here from work.
Oh.
That's okay.
Who else do we have?
Is Kareem Johnson on Zoom for Calvin Thompson? Those are the last two things on the docket.
maybe we should call, he didn't show up for, Kareem didn't show up for our case yesterday, isn't that right?
That is true, but he did email me last time when he was unavailable.
Because
I
he was
haven't
in-
received anything this.
Because he was in trial yesterday.
What time
so
was
he
that
might-
scheduled for?
This one is scheduled for 3, so he's 13 minutes late at this point.
All right, well, let's give him some grace, but by the end of the day, maybe he's still in trial, but that does not, he needs to get another lawyer that removes these. That does not excuse ignoring the court.
He appeared in front of Judge Stokes this morning via Zoom.
Yes.
Well,
He will be late to, an email came through, he will be late to the hearing.
how late?
It just says he will be late. He's still in Washtenaw at 2 o'clock. He's still in Washtenaw County and will be late to the 3 p.m. hearing.
Well, he can pull over and be on Zoom. Where's his client?
In custody.
There's a bench warrant in there. Or probation
Well,
violation.
I mean, he might be pulling over and doing it on Zoom, but I'm not gonna wait.
Understood.
Who are we doing this?
We're waiting on the victim family on Gordon, and we're waiting on Kareem Johnson on Calvin Thomas. Or Thompson.
And then we're done with everything else?
Correct.
Wow.
No worries.
Yeah, you can get on Zoom. I'm not waiting, or you can show up tomorrow. I can also just arraign his client.
Would he need time to talk to his client, Judge?
Yeah, probably.
Because he hasn't seen his client yet.
Oh, geez. Why don't we just move it to tomorrow? Go see what Nicole scheduled something for tomorrow. We can just reschedule them to tomorrow. Thanks for letting me know. How are you doing?
Good, how are you?
Oh, entertained.
Yeah, you said the S word on the record.
I'm a military potty mouth. I know,
Oh,
right?
like the real last word? I thought you meant slow or something like that, like.
Yeah, silly.
Oh.
But it rhymed with city.
Mm-hmm. Mm-hmm.
Kennedy says worse.
I'm sure he does.
Could be.
Right?
I mean, we have just had a cast of characters today.
Oh, while we're waiting, the guy who said I don't deal with guns too much, the guy that had like a. Did you hear how much his voice sounded like Brian's voice?
Oh, no.
His voice sounded just like your voice.
What?
The guy who was like, I don't really deal with drugs very much, or
Guns.
guns very much.
Oh, yeah.
Did you hear how much he sounded like you?
No.
Like, I don't mean like the way he talked, I mean, his voice sounded like.
Oh, no, I didn't
Wow.
hear it. I didn't catch it.
I was like,
Oh, I didn't either until you mentioned it,
You
and then I put it
Oh, I
on.
have one.
I walked
I like
in and thought, whose voice is that? And then I went, oh, it sounds just like Brian.
There is nothing set tomorrow, Judge, because you were gonna do errands tomorrow and didn't want just one big set, so there's nothing set tomorrow.
Oh, didn't she set something for Monday? I think Monday or Tuesday. It's set up for Tuesday. I don't mind any inconvenience in that.
I talked to mom, she's waiting. Oh, yeah.
Do we have defense attorney for the next one? Who's the defense attorney on the next one?
Gordon, that would be free.
One of the things we
That's what I have, but it's not here.
That's why I always have an Excel
Oh, yes.
spreadsheet that had the exact.
So I can put his name
Right
down
then
and you're not gonna make
stuff.
me like white it out. It's corrected. This is full of white out.
What are you taking in consideration? Putting a cash amount on here? Like, where do you get that?
Kind of the it's kind of like a severity of the crime. Just kind of want to send it to their brain and like. That's no.
I think the last one was like 100,000. I don't know if I've seen you do too many.
Oh, yeah, it was a good seat.
Yeah. I just wondered, 'cause I
He's
guess the
got
answer
to be in
is-
trouble with PR. Well, and this recording.
Do you understand it's hard to play around? I encourage you to walk out. Sure. I'm not gonna encourage you to pay for it.
Yeah, for sure.
That's fine, okay, that makes sense. Yeah.
So if they don't show up, then potentially. But hopefully it scares some.
Yeah.
But it also allows like fun, like serious, it's like that, like $500. PR bond.
Yeah.
She accidentally went to 54 and she's on her way.
At least you didn't go to 55th.
No, the exam was at 54A. She was on Zoom last week, but the Zoom didn't work. And this week I told her, since the sentencing is much later in the day, I think you should come in person in case, like, I didn't know at the time whether the Zoom would be working or not. So,
Yeah, Zoom's kind of weird.
yeah.
Plus this courthouse, I guess there was a phone problem, so when there was a phone problem, there ended up being a Zoom problem.
And so last week when it got bumped because of that, I said, look, I can't predict if the phone problem's gonna be fixed.
Right.
So. And it lasted for days.
That's not.
Did you move from Wayne? A minute?
No, Your Honor, I think we. We're ready, Your Honor.
Thank you. This is docket 24919 FH, People of the State of Michigan versus Calvin Lewis Thompson. Counsel, your appearance for the record.
Good afternoon, Your Honor. A.K. Burbucks on behalf of the people of the state of Michigan.
Good afternoon, Mayor. Please, Honorable Court, Kareem Johnson, on behalf of Mr. Thompson, standing to my immediate right.
Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide to be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes, Your Honor.
Thank you. Put your hand down. Sir, you were placed on probation after pleading to child abuse 4th degree, punishable by 1 year misdemeanor. Do you recall that?
Yes, Your Honor.
And I have a bench warrant here that states on or about, must be one, I don't know what 1531 is.
It should be 12, Your Honor. That's a
Okay.
typographical error.
Okay. I was gonna guess, but thank you for letting me know that. Okay. On or about December 31, 2025 and January 22nd, 2026, defendant consumed alcohol. Count 2. On January 30th, 2026, it was discovered defendant changed his residence without informing probation. Count 3, on or about January 22nd, 2026, defendant engaged in assaultive, abusive, threatening behavior toward Isabella Laguna. Isabella Laguna. Count 4, on or about January 22nd, 2026, defendant was arrested for assault with intent to do great bodily harm less than murder, larceny from a person, and domestic violence. Counsel, are you satisfied with the reading and waiving further arraignment? We can only proceed on counts 1 and 2 before you tell me that.
That's correct, Your Honor, we do.
All right, so are there any amendments?
No, Your Honor.
All right, counts 3 and 4 would be held in abeyance. Counsel, you've had an opportunity to discuss counts 1 and 2 with your client,
Yes, Your Honor, I have. Yes.
and sir, you understand them?
Yes.
All right, and you've had an opportunity to discuss them with your attorney?
Yes, Your Honor.
Will this be a plea or a hearing, counsel?
It's be a plea, Your Honor.
Is that correct, sir?
Yes, Your Honor.
And this plea is made of your own free will?
Yes, Your Honor.
After you've discussed everything with your attorney?
Yes, Your
And
Honor.
you've been satisfied with your attorney?
Yes.
And you understand I'm holding in abeyance count 3 and 4 because if you pled to those, you'd be violating your constitutional right to a presumption of innocence.
Yes, Your Honor.
Understand that? Okay. So as to, before you plead, have you taken any medication yesterday or today?
No, Your
You're
Honor.
supposed to be on any medication you're not on?
No, Your
Any
Honor.
sign of fever, COVID, or other illness?
No, Your Honor.
As to count 1, on or about December 31st, 2025 and January 22nd, 2026, consuming alcohol, how do you plead?
Guilty.
As to count 2, on January 30th, 26, it was discovered that defendant changed his residence without informing probation. How do you plead?
Guilty, Your Honor.
Did anyone force, threaten, or coerce you to plead?
No, Your
Did
Honor.
anyone promise you anything would cause you to plead?
No, Your Honor.
You just pled of your own free will?
Yes, Your Honor.
You knew the conditions of probation, you needed to, within 24 hours, advise probation of any change of employment, cell phone address, et cetera, and you failed to advise them timely of your change of residence, is that correct?
Yes, Your Honor.
And you also knew that there was no drugs, alcohol, or any medications that we were not advised of, and you in fact consumed alcohol on those 2 days?
Yes, Your Honor.
Was there a test on those 2 days, or did you admit to that?
Huh?
Were you tested on those 2 dates? Is that how they found out, or did you admit to that?
I admit to that.
Okay, and you didn't have any medication that had alcohol, you just drank alcohol?
Yes,
Is that
Your Honor.
correct? All right. I find defendant's plea has been freely, voluntarily, knowingly, and understandingly made. He's admitted to consuming alcohol of his own free will, no prescription or medication, and he changed his residence and didn't timely inform probation. Therefore, you are in contempt of court. Count 1 and 2 will enter. Count 3 and 4 held in abeyance. May we go into sentencing, counsel?
Yes, Your Honor.
What's the recommendation we have for probation? And with that, could you tell me what, if anything, he's completed?
Yes, Mr. Thompson has been referred to cognitive behavioral therapy class. I have a list of his attended dates. He's attended on 7 occasions, it looks like. And then once he was incarcerated, obviously he hasn't attended since. As far as the recommendation for a sanction, I did talk to Mr. Thompson regarding kind of his pending case and the ongoing case that he has going on. I was gonna recommend a revocation of his probation. However, given that both counts 3 and 4 were held in advance, I would be forced to recommend just a 30-day jail sanction and probation continued. Although I do feel that this is gonna be a continued problem on probation, Mr. Thompson, outside of just the alleged incident. He had several police contacts of continuous due to domestic altercations and verbal arguments with his partner, and I kind of foresee us being right back here on another violation. He did seem agreeable to not continue his probation sentence, but given counts 3 and 4 being held in advance, I would have to recommend just a 30-day jail sanction.
I'm sorry, I didn't hear the end, but given counts 3 and 4 being held in advance, what?
I must recommend 30 days jail sanction with probation continued.
Are any of these new charges or pending charges with the protected people under this law?
No.
On behalf of the people?
Your Honor, I would agree with the recommendation by probation, given the count 3 and count 4 being held in advance. Just for your Honor's knowledge, I do see that this is set for preliminary examination, the other file on March 10th at 9:30 at the 55th District Court.
Thank you. Counsel?
Yeah, we agree with the recommendation, and I've talked to my client. We're gonna try and waive that preliminary examinations. I was in a trial, the original examination day. Complaining witness did not show up, but the people were gonna proceed using the hearsay statute. So I've explained that to my client. There's no reason to wait till March 10th. So we're gonna try and get that waived as soon as possible.
Okay. Sir, what would you like me to know? Yeah, don't comment on the other cases or counts 3 and 4.
I don't have nothing to say.
So why are you drinking alcohol?
That day I was celebrating my brother's birthday. Just had a few drinks.
It's not just had a few drinks, you just had a few violations.
Right.
You made a conscious decision to violate.
Right.
So were you with your brother?
Yes, I was with my brother.
Is your brother on probation or parole?
No.
What's he do?
He works for a construction company.
So he knows you're on probation, right?
Right.
Isn't he saying, hey, dude, don't have a drink?
He should have been.
Yeah, he needs to be saying, hey, brother, don't have a drink. I'll drink for you, or I won't drink in front of you. I'll have a Coca-Cola or whatever it is you'd like to drink. That's non-alcoholic. He didn't do you any favors,
No, he didn't.
but you ultimately made the decision. So how long has he been in on this?
Has he been in, I'm sorry?
How long has he been incarcerated on this since he was picked up?
Well, he was picked up on the pending charge of 122. However, I started his credits at the time that the bench warrant was signed. So he currently has 14 days credit on the current violation.
Okay, and I'm sorry, when's the prelim? You're gonna waive it?
March 10th, Your Honor.
All right, 30 days with credit for 14. Actually, it wouldn't be credit for 14. He already has 10, right?
Yes, so he has 10 previously from his initial sentence and then 14 on this violation.
I'd recommend an additional 30 on top of the 10 he's already served.
Okay, so 40 days credit for 24 days.
Correct.
I'll see you in a couple of weeks, sir. While you're in there, attend AA, NACA. I don't know how much treatment you can get in there, but if you get into some classes, you ought to do it. I don't know what's going on. Maybe, I think I'm gonna recommend CMH to go see you. Sounds to me like you've got some anger issues or some trauma you're trying to shut down, or something's going on with you, sir. It's not normal to have all these files and charges, and they seem to stem from somewhere deep. So there's some trauma there, and you're pushing it out on other people. Let's get to the bottom of it. Don't have to tell me what it is, but you do need to resolve it. Unless you want to spend more time in jail or prison. Well, do you know what's eating at you?
I'm trying to figure that out now.
Well, we're gonna have some help over there. I want added to his probation, some individual therapy.
Yes, right.
You have 42 days to appeal and to request appellate counsel.
Everybody do that.
Good on this one. Recording now.
Okay. This is docket 24-574FH, People of the State of Michigan versus Christopher Gordon. Counsel, your appearance for the record.
Good afternoon, Your Honor. Angela Delvero on behalf of the people.
Good afternoon, Your Honor. Stephen A. Freeman, Public Defender, appearing on behalf of Mr. Gordon, who stands to my right.
Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes, Your Honor.
So you put your hand down. Have you taken any medication yesterday or today?
No, Your Honor.
Are you supposed to be on medication you're not on?
No, Your Honor.
Any sign of fever, COVID, or other illness?
No, Your Honor.
Have you had no time to speak with your attorney?
Yes, Your Honor.
Have you had some time to review the pre-sentence investigation report?
Yes, Your Honor.
Thank you. Counsel, are you, any corrections, additions, solutions? You said you're looking something.
I think he's looking to me. We have some agreed upon changes, Your Honor, so.
Did you need a moment or?
No, I know there.
All right, you may proceed as to the body.
Thank you, Your Honor. At the top of the pre-sentence report, the sentencing date should be changed to today.
So today is the 26th.
That's
And
correct.
that would be also on the basic information sheet.
That's correct.
It's also under evaluation plan, last line, first paragraph. And then it's likely under instant offense, and I've already put it on the sentencing guideline sheet, so. Instant offense. I'm changing that as well. Is there anything else?
That will then increase his credit to 8 for 8 more days, which makes a total of 650.
All right. The basic information sheet, cover page, the recommendation sheet. We're also changing the date. And a couple of places on the recommendation. Changing the 650. And under the recommendation narrative, I'm changing it to 650. That's probably everywhere it's at. Is there anything else?
In the boxes for his prior criminal history, we have a couple corrections.
Okay. Which boxes?
The first one is 6 of 6.
Okay.
Where it says attorney present unknown, that should say public defender.
Okay.
And then on that is 3 of 12.
Yes.
Attorney present instead of unknown should say public defender.
Okay.
5 of 12, the same correction.
And for the record, I'm putting yes, comma, public defender.
And then on 7 of 12, it should be yes, and then the Florida lien says assigned counsel. As opposed to public defender, I don't know what the difference is, but.
Just Florida being Florida.
Yep, 10 of 12 should say yes, public defender for attorney present. And that's all of those corrections.
Okay.
Now, I don't have any other factual corrections. We have, I think, an agreed upon guideline correction, which is discussed in the evaluation and plan. So it's sort of both factual and a guidelines correction.
Okay, where's the, let's just go to the, if it's agreed to, let's go to the recommendation narrative. So the guidelines range changed to what?
So, well, so at the bottom of what's called, like at the bottom of what is labeled as page 2, above where it says compass chart, where they justify the scoring of the sentencing guidelines.
Yes.
I would concede, I do not think OB 19 should be scored at 15 points. And
Okay.
so that's gonna.
So what should it be scored at?
0.
I'm just gonna put 0.
So we can just take out that whole paragraph. And then that correction would need to be made on the guidelines sheet as well. And then I don't know if it ultimately council is going to agree that OB 8 should be scored at 15 or not. If not, I have an argument for that. So otherwise, I'm now done with any corrections that I knew about.
Okay, so does the range change?
I think it will.
Okay.
But it also, if the court ends up ruling differently on OB 8, it also could change.
Okay. What about OB 8?
Yes, Your Honor, thank you very much. Counsel and I have had an opportunity to discuss this report more than once, I believe now. And I am moving the court to change the OV8 from the currently scored 15 points to 0. And the reason is because in order to score points, oops, my hearing just went up. There. OV8, of course, is for victim exportation or captivity. A victim was exported to another place of greater danger. I don't think that that's our case. Or to a situation of greater danger. Again, I don't believe that that's our situation here. Or was held captive beyond the time necessary to commit the offense. The offense was criminal sexual conduct in the second degree. The 9-year-old child indicated that she used the word humped. He was humping me from behind. And I don't know that this court or counsel or myself can speculate as to what length of time is required to complete that. It was not a question of starting and stopping. My understanding is it was a continuous event, and that there was no indication of any sexual climax of any kind. But so the question is, well, how long, how can we say that she was held beyond the time necessary to commit the offense? I just don't see that that's logical or practical for us to try to make that determination. She did indicate that the defendant did have his arms around her waist or her stomach area. That's true. And that he was holding her in place. But even so, how does that correspond to creating a situation where it was beyond the time necessary to commit the offense, not complete, but to commit? And so I just don't see it as being scorable at all. Thank you.
Response? What the case law says, Your Honor, as it relates to that precise issue, is that once conduct is done that meets the elements of the offense, the crime is complete. Once his genitalia touched her buttocks once, the crime is complete. The facts that are in the pre-sentence report indicate that he was forcibly humping her, meaning that his genitalia touched her buttocks at least once. But additionally, and I should have actually noted this when I was talking to the court about factual changes, at the preliminary exam, and I would be asking the court to add this language to that paragraph for the justification of OV8. At the preliminary exam, she went further to state that she told him to stop. He said no, and she had to bite him in order to get away. That's clear that there was at least one touching that was a CSC second prior to her attempting to get away, forcing her to bite him, which means that she was held beyond the time necessary to commit the offense.
Anything further, counsel?
That reasoning suggests that 2 seconds would be a sufficient amount of time to complete the act.
I agree with that.
That would be a sufficient amount of time to complete the act. And it, as we are all instructed, the time necessary to commit the offense. I don't know that there is an exact time to commit that offense, even as described by the 9-year-old.
I think even the Supreme Court has ruled on this. I think it's in the jury instructions, is no matter how long, it's the touching. So I agree with the people adopt their argument and totally disagree with you, but nice try, counsel. It is 15.
Judge, will you add a sentence on that same page 2 underneath the paragraph justifying OV8 that says at preliminary exam, the victim testified that she was forced to bite the defendant before he would let her go?
Yes, I will. It's been added.
Thank you, Your Honor. So with the subtraction of 15 points, which I conceded to on OB 19, that is, so I think 50 minus 15 is 35, if I'm never claimed to be a mathematician.
I think you're right, but I'm not a mathematician either.
Yeah, it's 35. I just double checked it on my phone. So it's a C grid, 40 and 35 makes him that makes the OB level now 4 instead of 5. Makes the guidelines 36 to 71.
All right, so I changed that on the recommendation narrative. I changed it on the sentencing guideline sheet. I need to change it on the basic information sheet. So just give me a moment. I'll change the range and the score. All right, anything else?
I don't have any other changes or arguments as to the guidelines, Your Honor. I
Counsel,
do.
do you?
Thank you, Your Honor. I have no objections to the prior record variable as scored, but I would indicate for this record and just to preserve a point, I initially, when I reviewed this report, I saw that there were a number of entries from the state of Florida, vast majority. And I also saw that there was indications of either unknown or none, where whether there was an attorney present. And I brought that issue up and was informed that when the author of our report was gathering that information, apparently the equivalent of lien is different than the state of Michigan, and that information was there but not readily apparent. And therefore, I asked that those indications where there was in fact, whether appointed or not, there was a lawyer there, and that was addressed. And so I'm no longer concerned about that. And I just wanted to indicate that for the
I
court.
appreciate that. That correction's been made throughout, I believe. So thank you for that correction. And with the scoring, with everything being done, sir, I'm not sure when you came on, I advised you, but just so you remember, you pled guilty to count 1, criminal sexual conduct, 2nd degree, person under 13, defendant 17 years or older, which is punishable by 15 years. Do you recall that?
Yes, ma'am.
Thank you. On behalf of the people, do we have a victim or a representative of the victim here?
We do, Your Honor. Miranda Houston, her first name is spelled Maranda, so spelled a little differently, is the mother of Amaya Houston. She's here to speak.
Thank you. I appreciate you being here, ma'am. You may come to the podium.
Would you like to do there or there? Okay, I'll stand with you.
Please raise your right hand. Do you swear or affirm the testimony you're about to provide to be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes, Your Honor.
Thank you. Put your hand down. And counsel just spelled your name. Did she spell it correctly?
Yes.
All right, thank you. Now, we can move that microphone a little closer to you. That'd be great. If you need to take a break, go ahead, and you should keep your voice up. I don't know if you're reading something or not, but pretend you're reading to a 5-year-old, okay? People tend to go really, really quickly. They're a little nervous. Just pretend we're having coffee and you're talking to me. Because I got a court reporter over here who's had a long day, go really fast. She might miss a word, and it's important that we make a good transcript. Do you understand?
Yes.
Okay, thank you. You may proceed when you're ready.
We live in a world where children are further desensitized by traumatic experiences due to no control of their own. Every day, we as adults have a choice in our behavior that impacts the trajectory of our children's lives, both directly and indirectly. I wish that someone loved and protected you when you were sexually abused. I wish that the healing that needs to be done in your family is underway. I wish that my daughter felt safe enough to be in this courtroom to hear you say you're sorry. I wish that your other children can experience real love from a father that cares, supports, motivates, and encourages them to be better for themselves and for their community. I wish that you find accountability within yourself to move forward in life differently. No more running from your problems because you're creating problems for those that are around you. Remember what it felt like to not have someone on your side fighting for you, believing in you. Hiding in your shadows of your truth, only for it to be revealed through your behaviors. I've watched you show up in this courtroom with all the sense I've known you to have, yet no audacity for the table I've extended to you in your times of need. Your slander, the grace, the position and sacrifices I've made for your behalf and your satisfaction. It's very disgusting to be on the opposite end of a lens and watch you in your presence and still hear your lack of remorse you have for the kids that you traumatized. I can accept the things that I cannot change. But kids still need help understanding why. I'm here today to ask for justice, at least for one of my daughters. I stand here with the firm belief that you've stolen the innocence of my children and shook our household.
And what our household?
It shook our household. I hold no haste at your relationship decisions and was willing to let you live a life outside of my home. You didn't disclose you had warrants or tendencies to touch children, and as one of the least judgmental people you know, I would have tried to get you some help. Yet, I had to sit with the reality that you might not want it. And maybe that's because you don't see the fault in your stars, or that you might have misguided behaviors and you're not responsible to your own needs. I want to thank you, Judge, for demonstrating patience and understanding in all of those before me as I've witnessed. It's because of your strength and tenacity that I can pull through rough days. As behavior interventionist from school, I get days off and vacations and time to be away from all the duties of work. It's still a rough job in the schools, but I can't imagine hearing indescribable acts of adults and still having the grace to just be calm and cute. Women like you are inspiring to daughters like mine with the knowledge to lead and excel in all that you do. Showing up is the easy part. Having the tenacity is the admirable act of service. Thank you.
Man, I'm not the strong one here, you are. Stand here, loving your daughter and knowing what she did and speak on her behalf. That's a true hero. And that's what you are, you're the strong one. And your daughter has just an amazing role model. And the reason she's gonna get through this is because of you. Now, is the restitution that you're seeking, is she in therapy? Is there any money that you are spending because of what he did?
No.
Okay. I am going to order, if it's okay with you. I've done this many times. As far as I know, I'm the only judge that does it. And at some point, maybe somebody will tell me I can't do it, but I really don't care. I'm gonna keep doing it. I'm gonna order a copy of this transcript. If you would like, you can also have a copy of the plea transcript. The reason I do that isn't to hurt you or your daughter, but as your daughter gets older, and she's certainly going to remember these events, she's going to need her own therapist, who I call a secret keeper. So she can have a conversation to know that her mother spoke on her behalf, that her mother stood up for her, that the court listened, the prosecutor listened, and that justice, as good as it can be, can't return things backwards, but it can change her life and the life of others because of you and your daughter speaking up. he cannot offend anyone else, at least while he's in lockup, and we're gonna try to get him some treatment. So I want to know that, her to know that she was heard. And I believe that a therapist is only as good as the knowledge they have. So this would be given to you in a sealed envelope. If you want to read it, that's fine, but I would suggest that you only reveal it to her therapist and to her when she's of age, so that it can be used in her therapy to help her become whole and happy, know that she is clean and safe, and she did nothing wrong, that he did everything wrong, and that you also did everything right. So is that all right with you, ma'am?
Yeah, sure.
Okay, so the crime victims unit will be giving that to you, and then you know how to use it and put it in a safe place. What I have found in all the years of listening to this is that trauma lives in the body, and that at different times, victims are going to remember different things, and as she gets older, as a boyfriend, a husband, children, this is going to come up, and she may not know why she's skittish, afraid, upset. And so this can be used in her treatment, and I think that's at least the restitution that you can pay for, this transcript. I really, really appreciate your strong voice and you protecting all our kids, because when you report, when you stand up and say no, then you are the example for others who don't have that strength. So you and your daughter are both heroes. Thank you for being here.
Judge, if your court reporter puts those transcripts to my attention, I'll make sure they get to the right people to make sure they get to Mrs. Houston.
Thank you.
Counsel?
Your Honor, as it relates to allocation, would the court like me to make my allocation now?
Yes.
Okay. I did want to bring this is, I think, a potential legal issue that I think we need to bring to the court's attention. When we negotiated this plea bargain, part of the plea bargain, well, I won't say that. The plea bargain was made in contemplation that dismissing one count of CSC 2 would drop the guidelines to 29 to 57. I did not realize there was a juvenile history in Florida that I had some of, not all of it, when we calculated the guidelines. So the probation found a little bit more. That's what made the guidelines ultimately 36 to 71. I think there's a new case and a new court rule that indicates that although that might not be part of a plea agreement, which it was not, that if it's explicitly articulated that it is the motivation for the plea agreement, that it might as well have been part of the plea agreement. So I'm going to ask the court to sentence the defendant within the range of 29 to 57 months. I'm actually going to ask the court to sentence him at the top of the guidelines to 57 months. Because ultimately I think that's fair. That's what we thought the negotiated plea agreement was going to have the guidelines as. That's what I consulted with Mrs. Houston about. But I think the law actually requires that. So I'm going to ask the court to sentence him to a sentence in the Michigan Department of Corrections of 57 months to 15 years with credit that he's entitled to. That also will require lifetime electronic monitoring is already on there. And I would ask the court order as a condition of parole that he have no contact with Amaya Houston. It's Amaya Houston, Miranda Houston. How do you say Camille? And Camilla Gordon, which is Kameeah. That is Amaya's little sister. Gordon spelled Gordon. And I don't have anything additional to add.
Is it Gordan?
O-N.
O-N, okay. Thank you. Counsel?
Your Honor, there were some typographical errors that I did not bring to the court's attention because I think the reader of this report can understand what was meant. So I
Do you want to bring them up now or no?
no, Your Honor, I would rather focus on
Okay.
what I believe to be important in the court's decision-making. Being a parent myself, I absolutely can understand and appreciate Ms. Houston and her position. She's here acting as an advocate on behalf of her child. I agree with the comments and sentiments offered by the court. I say that to now say this. Based on my reading of the pre-sentence investigation report, particularly on page 5 of form number 284, I'm concerned that when the court read it, it could take it into consideration in terms of fashioning a sentence, because
The court read what?
she indicates, after I withdrew her daughter from daycare, you, meaning the defendant, began watching her. I should have had her tested then. I can't imagine what she would have her tested for. The daughter was admitted to the hospital for UTI, urinary tract infection. I cannot imagine how that is associated with this case.
Because UTIs, every woman knows, I suppose men don't know this, but UTIs are, especially in children, are an indicator that there may be sex happening, and newlyweds get UTIs all the time. And ask every hotel that has a newlywed suite, they have a doctor who's seeing the newlywed. That's why.
Yes, Your Honor. And this is a criminal sexual conduct in the second degree, where it's undisputed that the child was fully clothed.
I got that.
Okay.
But as a parent, and you just said you're a parent, I would have the same exact concern. Is there something else going on that I need to know about? And there's lots of medical reasons that happens, but there's also sexual reasons and concerns. So as a parent, I think it's right for her to go through that thought, to go through her mind and to go through those machinations of how did she get this? So I don't fault her. It's not something I'm considering. I'll just say that for the record. Thank you.
Thank you very much, Your Honor. My concern as the court, I think indirectly indicated, is that I was thinking that perhaps Ms. Houston was confusing the facts of this case with an actual act of sexual intercourse. And if that was the case, I just wanted to make that clear. I'm comforted by the court's comments. Thank you very much. The other aspect that I wish to bring to the court's attention is that while my client has been in jail for quite some time, he has not been sitting idly. I know that the author of our report indicated that he is in the process of completing his general education degree. He has completed the PATS coping skills program. He showed the probation agent certificates of completion. That was also included an anger management class, some mental health issues, and employment. So he has taken it upon himself to try to rehabilitate himself while he has been incarcerated, and I think that is something of significance for consideration. With respect to the actual sentence imposed, I know that my client is going to speak to the court in just a moment, but we all know that if this court imposes a sentence that is within the agreed upon now calculation of the guidelines, it is presumptively proportional. And I too would respectfully move the court to sentence him within the guidelines. On the other hand, given the totality of this case, I respectfully move the court to sentence him to a term a lot closer to the minimum, respectfully 36 months to 180 months, if that would please the court.
Thank you. Sir, what would you like me to know?
Well, I do apologize for my negligence and
not being able to make her feel comfortable to come to me and talk to me about.
I didn't get that. And not being able to meet what?
Not making her feel comfortable enough to come tell me what was going on.
You mean the little girl?
Yes.
Wait a minute.
And,
You're apologizing for negligence for her not telling you what was going on when you are trying to have sex with her, although fully clothed? Is that what you're telling me?
no, that's not why.
Then explain what you mean, sir.
Just me being a father, I haven't made her feel comfortable to tell me about what's going on because I didn't.
Why do you think a victim has to tell you what's going on? You're the adult, you know what's going on, and you knew it was wrong. No means no. She had to bite you to stop. She did tell you, and you didn't stop, and she bit you. I'm not understanding this at all. I don't think you learned anything from those classes.
I have learned from my classes, Your Honor.
Then speak in English or make up a different story, because I'm not believing a word coming out of your mouth.
I just really apologize for my negligence.
Sir, you are 33 years old.
Yes, Your Honor.
Sorry, I don't understand. Sorry doesn't understand now. All right, look, you're 33 years old. You have a criminal history that I could wallpaper a room with. You have a juvenile history that's extensive. Granted, a lot of things were dismissed. I don't know what happened there. There's lots of reasons things get dismissed. But then you have a dozen times you were in front of a judge or in a court as an adult. And again, a lot of things were dismissed. But then you don't get so lucky. In 2011, you have resisting an officer. Couple days jail, probation. Again, you have dismissal of very serious charges. I don't know. So you're presumed innocent, but when I look at this pattern here, and you finally then get a battery charge in 2016. Some more assault of crimes that are dismissed, and then you have a drug possession.
That too, was also dismissed.
You what?
That too was also dismissed.
I have 60 days jail, fines and costs, so it wasn't dismissed. Controlled substance possession.
They didn't charge me, that was thrown out.
Not what it says here. Do we need to amend this further? What was this counted?
Which count, I'm sorry?
7 of 12 in 2022. He had a possession of a controlled substance.
Well,
Looks like it was a plea, 60 days jail, fines and costs.
I can tell you that I verified it in the lien because that's how I knew to have you do the correction assigned counsel.
Yeah.
It shows as a plea in the lien.
Then we have a theft of a vehicle, which just was dismissed. And then in 2023, we have resisting arrest, fraud, impersonation, fleeing, eluding, driving while license suspended. Not the worst crimes I've seen, but there is an escalation that I'm seeing. Because then we go to aggravated assault weapon. And then we have another thing that's dismissed. Now we have the biggest one, which is what you're facing now, criminal sexual conduct, 2nd degree. And what really, really concerns me is when I look at, let me just find it here, the narrative, I think this is what you were talking about. You said defendant denied that he is interested in any fetishes, voyeurism, attraction to pre-pubescent females, males, or anything else he felt worth noting. Well, we have a pre-pubescent female here that you engage in a sexual act with. So you admitted to it, but you deny it here. I don't think you are being truthful nor truly accountable. I appreciate that you've done some work while in jail and you have not been idle, but the work that you need to do is on the criminal sexual conduct. And sir, I don't like this deal. I don't like these guidelines. I do have the ability to sentence you 10 to 15. That would be 120 months to 180 months. And that's what I feel like doing. Because you aren't getting it. And because I believe that you need more time. However, because of this guideline debacle, and because I don't want this little girl to have to face a trial when the Court of Appeals tells me to re-sentence you, or you can withdraw your plea, all the other things, I think the family needs closure. I think mom's gonna get the help her daughter and her family needs. So I'm going to sentence you to the Michigan Department of Corrections for 50 to 57 months, which is the high end of the guidelines of what was anticipated and contemplated and discussed. 57 months to 180 months. You have credit for 650 days. You have lifetime electronic monitoring. You comply with SORA. You'll have no contact with the Houston and Gordon family, the mother, the daughters, no one. You communicate with them directly, indirectly, through third parties. You get creative and send a Christmas present, a Hallmark card, flowers, carrier pigeon, message, smoke signal. You communicate in any way, shape, or form. I will contact the warden and they will not allow you to have any communication. All your friends and family, if there are any who want to see you, will have to come see you wherever you are so situated. So don't tempt your fate, sir. You are going to pay for the costs of the plea and sentencing transcript. That is for the rehabilitation, health, welfare, safety of the little victim whose life you altered forever. She is no longer that innocent 9-year-old. Not only does she know things a 9-year-old should not know, but she lives in fear. God granted her a strong mother. And I believe that she will be healed, because she will never forget. And that trauma will live inside her and will rear its ugly head at times when you least expect it. And you caused that, and you had no right to cause that. No right to affect another human being. Is there anything else I need to address?
No, Your Honor, thank you.
Oh, there is, he has to pay $130 crime victims and $68 state costs.
For the record, I'm handing my client notice of right to appellate review.
So you have 42 days to appeal and to request appellate counsel. I'm waiving fines and attorney fees since you are indigent, estate cost, and the crime victims will be paid within a year after your release. The restitution will be paid immediately. 42 days to appeal to request appellate counsel. Do you acknowledge receiving your appellate rights?
You acknowledge that I gave you that form.
To appeal.
To appeal, if you would like to appeal this, that's how you do it. You only have 42 days to read it and consider it and fill it out. You understand?
Yes. Yes, Your Honor.
Any questions?
No, Your Honor.
All for the record.